Hello, everybody. How are y'all doing? Y'all can do better. Nice. Okay, so we're gonna do a land acknowledgement for all of y'all. So we take a moment to recognize that uncommon law occupies the ancestral and unceded land of the Ohlone tribe. This land was and continues to be great importance to the Ohlone people. We recognize that every staff member of Uncommon Law has and continues to benefit from the use and occupation of this land. We also want to acknowledge the lands that we all individually call home and the relationship we have to the stolen land. Consistent with our values of community, freedom, and justice, we have a responsibility to acknowledge and make visible the relationship we have to Native peoples.
As an organization committed to the freedom of incarcerated people, it is vital that we understand that liberation is tied to liberation of all peoples against systems of capitalism and settler colonialism. And so we enter this learning event with this intention set. Thank you.
Pass it back to Keith.
Thank you both. Thanks. So we are at Met West High School. We're also streaming live on all the normal platforms that I don't even know how to access on my computer. And we're at the Dolores Huerta campus, which is a really special place. I actually had the pleasure of meeting Dolores Huerta a couple of years ago and got to talk with her and learn from her about how in their organizing efforts, they help people understand the real power they have once they learn how to work together within and outside of the structures that exist. And that's kind of what we are trying to do here at Lifers, trying to support each other and figuring out how to navigate this process that is holding our folks in prison. And while there's plenty of time and opportunity to complain about the process, and we'll do that today a little bit. We're really focused on how we can help bring our folks home while it exists as it does now. I will say a little bit before we sort of get into the meat of it about the policy, like the context in which this process exists. And before I do that, I know I'm supposed to make sure you all know the restrooms are right there in this hallway. We still have plenty of muffins and things on the other side if anybody wants to. Everybody should take some of those if we haven't already. But I mentioned the policy piece because this modern parole process we're going to be talking about today has been shaped by a whole series of laws, regulations, the policy decisions about the last 40 to 50, almost 50 years. And it hasn't changed that much in that amount of time. There have been more and more people who get to go to the parole board. There have been some new policies put in place that require things like a hearing, that require that people get an attorney appointed, that they get access to the file that the board's going to be using when they decide their cases. A few other pieces that have shaped this process. But the most recent changes seem to be sending more people through this process, like sentencing law changes, are sending more people to the parole board, but it hasn't had enough of an impact on the percentage of people actually being granted parole when they go. More people going to the parole board, but still being denied some of the rates. Things have gotten a little better. We got a long, long way to go. And we were going to have a session talking about policy development, how we're working to try to shape the policy landscape in California. We have decided not to do that session, partly because our senior policy manager is not available, and because we have our wonderful policy associate, who is Hemba, you just heard from Hemba, who has put together, the table over there has a lot of policy information. She's going to do a quick, couple minutes to share how you can learn about and stay engaged in the efforts to help shape policy landscape here in California as it relates to the parole process. Come on.
Hello again. So as Keith mentioned, in the back, there's a policy table which has resources from Common Law, Initiate Justice, and Ella Baker Center that allows y'all to understand what are ways that I can plug in. How do I become a better advocate? How, as somebody who, really cares about folks inside and my loved ones, do I make sure that I create change for everybody? And so back there, you can sign up for something called CAPER's listserv. So CAPER is a California Alliance for Parole Reform, which is a coalition that Uncommon Law and a multitude of different organizations across California that are part of, who are committed to changing the way that the discretionary parole system is working. And obviously, as we know, it is not working for our folks. And so we're trying to change that. And so if you want to plug in, you want to learn how to really get involved and just maybe learn about ways that we have engaged folks, you can go to the back and scan a QR code. And these are just a few ways that you can get plugged in. Also, the 2023 legislative session just ended. So if you would like to have some bill highlights, we have a whole sheet that explains what bills passed, what bills failed, and what bills are still in the running, because we're in a 2-year session, which means that there's bills that are going to have a 2-year process to be potentially passed. And so if you would like to learn about that, you can get a bill highlights as well as an SB 81 update, which is something that I know a lot of folks were looking forward to, but it was unfortunately vetoed. And so if you want to learn about what that was and why it was vetoed, you can also get a sheet for that. So thank you so much. I will be there for any questions. And yeah, only because we didn't get the workshop done doesn't mean we don't want to engage with y'all. We really want to engage with y'all. So please, please, please come to the back and get to know me. And Sue will hopefully also, who our senior policy manager, might pop up. So yeah, thank you.
Thanks. And you know, the over the last, I guess, about 20 years, the parole grant rate has increased a little bit. When I first started doing this a little over 20 years ago, it was only about 1%. 1% of the time when you went to the parole board, you could expect to get paid. At the time, the governor reversed 99% of those. Now it's up to about 14%. Completely unacceptable. But it is an improvement. But that improvement happened because of folks inside. Because they litigated, because they pushed for legislation. They wrote a lot of the policy that they wanted to see, the way they wanted to see things change, and eventually folks started to listen. And also folks on the outside were pushing lawmakers to do something different with this population that was stuck. So policy is a real thing. It's important. We have a whole team now devoted to it, in addition to the other work we do in Uncommon Law. So we're going to jump into it and try to cover a lot of things today. I guess I'm going to be playing a couple of different roles today. I'll try to balance them as best I can. But this is what it's going to look like today. So we've got introduction to the process, really an overview, and I'm going to provide that for the most part. And then and along the way, I'm going to encourage questions. Whatever questions you have as I'm going through, don't hesitate to make some noise. I'll give you the opportunity to ask that. I'll try to answer them. As I said, we're streaming this also. Folks who are watching it online need to submit their questions and comments. We can't respond to them live, but we'll capture all those and we'll follow up in response in the coming weeks. We're going to have a mock hearing. Emma, right here, one of our attorneys, and C, and Warren will be doing mock. We'll show you what this looks like and sounds like, and maybe the way to get it right or wrong. I don't know. We'll see how that plays out. And then we're going to take a break for lunch. We'll have lunch coming in. Is that Charlie too? Yeah. Okay, right on time. So Charlie's going to join that mock hearing crew, I think. It's still the plan. And then we'll have a break for lunch. And then in the afternoon, we got a couple of different workshops. We're going to do 3 different ones. And the first one is going to be about how to support your loved one through this process. We're going to do that right here in this main space. And then for the second session, we're going to have 2 different groups. One's going to be right here in this space, and that's how to work with your state appointed attorney. And that'll be led by Emma, who really wanted to be a state appointed attorney, but they wouldn't return her phone calls or anything. So she stuck with us, and Warren will show what that looks like. And I guess the good and the bad of that. And then the other session is going to be about different kind of special types of parole hearings the board is currently conducting. It's going to be in that room back there. One of our attorneys, Serena, who's not here yet, but she will be, I'm told. She'll be leading that conversation. And then, what else? And then at the end, we're going to have a panel with Warren's going to be there, C's going to be there, Michelle Scott will be here a little bit later. We'll have a conversation, maybe to fill in the gaps, the questions that come up during the day, and you get to hear from them and their experiences in dealing with this process and successfully navigating it and getting themselves home. I think that's it. Those are where the restrooms are. Got that out of the way. All right, so now I get to put this down and wait. I mean, follow these slides very closely. So what is this process we're talking about? We use the term discretionary parole. Sometimes we call it selective parole because they're really selective people they like to release. It's sort of what it is, what it feels like. And this section, I'm gonna break down what the legal framework is, what the process is, who's involved, who's on the board, what are the steps of the process along the way. Before the hearing, during the hearing, what happens after. And as I said before, feel free to ask questions along the way. I don't mind if we spend more time on one section than another. We will cover everything we need to. And somebody will tell me when we're actually out of time because I won't be able to do it. So what is this process? Most of the people who are sent to prison in California are serving determined or fixed terms. But there's a growing percentage now, it's now up to about a third or so, who are serving these indeterminate sentences. And they can only be released if the parole board says they can be released. And then there's another group of people who are serving really long fixed sentences that are long enough to be eligible for one of the kind of special programs we're going to talk about today. So they can be released if the parole board says they can. So altogether, it ends up being a little over half the prison population in California gets to go through or has to go through the parole process. And the law in California says that when someone goes to the board the very first time, there's a strong presumption in favor of them being released on parole. The law says the board shall normally grant parole. That has never really played out that way. As you can see here, rarely is anyone granted parole at their first hearing. It used to be something like 0.3% are granted parole at their first hearing. It's a little better now, but it's still very difficult to get a parole granted first hearing. And when you go to that first hearing, let's say you're serving a 7 to life sentence or something like attempted murder or kidnapping would be a 7 to life sentence. You go to the parole board, they say, we find that you're unsuitable for parole. They can put off your next hearing up to 15 years later. They have this whole range of options, 3 up to 15. It's really 15 down to 3 is sort of how it works. And the question the board is supposed to be asking and answering is, does this person present an unreasonable risk to public safety? If they think you do today, whatever the crime was, however long it was, if they think today you present an unreasonable risk, they will deny you parole. And they try to predict how much longer you're going to be this risk. 3, 5, 7, 10. This last point here is that we don't really get a lot of help in the courts. We've had some success. Again, a lot of that litigation driven by folks who've been through the process. But the courts, for the most part, will keep their hands off a parole decision. And they will look to see whether the parole board has pointed to any kind of evidence that could support that decision. And one of the main things they focus on now is this question of insight. Does this person have insight? Insight means a lot of things. and kind of nothing sometimes. It's in the eye of the beholder. Does this person have an understanding of the crime they committed? Do they have an accurate memory of what happened? They have a knowledge of who was involved, how they were hurt? Do they have an understanding of why they committed this crime? All the different factors. Do they have an understanding why they committed a rule violation 10 years ago that was completely unrelated to the crime? All these things fall in that category, and courts will let the parole board just go. Well, you made this statement that indicates you lack insight. You'll be denied parole. Some people will never be able to present in the way that will make the parole board feel comfortable, or at least it's very difficult for them to. This says 7,000 to 8,000 hearings. That's about right. Every year, the board is scheduling really up to 9,000 or so hearings get scheduled every year in California. There are a lot of them don't actually go forward, get completed for reasons we can talk about. We will talk about some of those reasons. Over the last few years, as I said, more and more people are going through this process. Some laws have changed and said, well, if somebody was especially young at the time of the crime, they should get a special parole hearing, almost no matter how long their sentence is. Or if someone is older now and served enough time, they should get a parole hearing. So more of those folks are going through. Sometimes people are serving life without the possibility of parole sentence, and those sentences get commuted, or some other really long sentence. It's commuted to one that allows them to be eligible for parole earlier. And some third strikers, people serving 25 to life sentences, this third strike, some of them get to go to the parole board and be reviewed for their, well, third strikers serving 25 to life do get to go to a full hearing. Other folks serving second, third strike sentences who may be reviewed by the board, but it's not necessarily a hearing. We won't spend a lot of time on that. It's really about the hearing. As I said, 14%. That was last year. The program rate was 14%, which was the lowest it has been in 5 years. And then this last line is really about saying, once people get out from these life sentences, they don't come back. Or pretty much anything. It's very consistently for many years, recidivism rate has been between 1% and 3% coming back for anything. And that means a felony that, and if you focused on violence, it's like a fraction of 1% ever come back for any violent crime. This is the safest population to be released, which most people don't really understand. The board clearly doesn't understand. Or the board thinks they're doing a really good job. They can say, we're only releasing the right ones, so pat us on the back. We don't do a lot of back patting around here. So this is the statute that creates that strong presumption. Most states don't have this. Board shall grant unless, most states do not have it, but that combination shall or unless is what creates constitutional protections. It's what gives us an ability to go to court and challenge a parole decision if the board denies it. Most states don't have it. States have we might look at you, we might give you a hearing, we might grant you if we get around to it, if we want to. And there's nothing you can do about it. You don't have a constitutional right to parole unless a state, an individual state creates it. California has created it with this language. And then the next section, 3041.5 says, well, if they deny you, here's when you get to be reconsidered. That's where the 3, 5, 7, 10, and 15 come from. It used to be people got annual parole hearings. You got denied this year, we'll see you next year. And in 2008, Marsy's law, which was a ballot initiative, and allowed them to push the next parole hearing out up to 15 years. This is about petitions to advance, just about we'll talk more about that later. If you are denied parole for really any length of time, anywhere 3 to 15 years, and sometime passes after that hearing and you feel like you've addressed the board's concerns, that 115 went away, or you've completed more programs, etc., you can petition the board to move up your next hearing And oftentimes they will grant that. You get an early hearing. I won't go through all of these, but basically, the statute says shall only grant parole, and then the board has developed and implemented these regulations that are supposed to guide their decision. How do we know whether somebody's suitable or not? So these are about these 15 different factors they consider. And it's not exactly a comparison, though. It's not how many on this side versus how many on that side do we have. Because the way the board operates, if they think there's even one thing on that right side, unsuitable side, that can be enough to deny your parole. And a lot of those are kind of subjective. It seems some of this looks like it should be fairly objective, kind of very straightforward. But things like unstable social history, number 3 on the right column, what does that mean? And what's really interesting is insight is not on here. It's not one of the factors in either column. It's not in the statute, it's not in the regulations. But the section that introduces this one says that the board can consider a person's past and present mental state regarding the crime. That's where insight. That's where they read insight into the regulations and they just operate like it's a real thing. The other thing that I like to point out about this, all these 15 different factors, is that this comes up pretty much with every workshop we do inside. Somebody says, what if you didn't do it? I didn't do this crime. What if you're actually innocent? How do I go show insight? How do I show remorse for something I didn't do? Or it didn't go down the way the board says it did? How do I get through this process? And I point out that out of these 15, none of them says didn't do it. It's not a way for the board to grant parole. If you're expecting it, you will not get it. Doesn't mean you have to say you did something that you didn't do. We can talk about that. But don't expect your innocence to be the reason they grant you parole, because it will not be. They don't know how to handle that kind of information. Any questions so far? Got a couple, go ahead. Yeah.
I mean, that feels like it's cutting against someone who a juvenile that they are, hadn't developed fully yet, and there's this space to grow. That's discussed, especially with the growth of the offender.
Yeah, your question is, well, this seems contrary to the set of laws and policies we passed to recognize that young people are supposed to be treated differently. The fact that they committed a crime when they were young shouldn't be the reason to deny them parole if they're given a youth parole hearing. And that's one of the things we'll talk about in one of the special sessions this afternoon, about what these special consideration categories are supposed to mean. But this is one way in which the board hasn't really done a good job of reconciling the way they've been operating for a long time with these new laws saying, give people special or different kinds of parole consideration. It's not supposed to be the same old parole here. This is why we have new laws. But they haven't really caught up. They go through the motions and say, we gave you the fact that you're young, special consideration, we gave great weight to it, is what they said. It just doesn't really play out there because they give a special hearing in name, but it's the same commissioners asking the same questions, using the same factors. There's another hand over here. Well, if you can define it, we'll do it together. The question was about the unstable social history. What does that mean? Can we define it? The board looks at this. Is interesting. It relates to the other question, which is the board looks at things like, well, what was your life like at home? Was there violence in the home? Was there substance abuse in the home? Was there divorce or some, departure from the home, were one of your parents arrested? Were you a survivor of domestic violence? All that fits into unstable social issue. And the board sees that as indicating that you might be more of a risk now. Doesn't make any sense. But that's what they do. Go ahead, Jimmy.
And you, 30 years later, you're part of the whole. Sealed, 12 years old. But they always seem to say, well, what about the
Right. So you're asking, yeah. So we have procedures that allow juvenile records to be sealed. You're saying, shouldn't that mean something? Why should the parole board 30, 40, 50, 60 years later be able to look at and ask you about those things that were technically sealed because you were young and dumb at the time? The parole board is guided by consideration of information they think is relevant and reliable. And they think a conviction or a petition that was sustained when you were young is a reliable information about your misconduct. And therefore, you need to own up to it. You need to show insight into it. And part of this kind of goes back to the policy conversation. I don't want to go too far down this road. A big part of why you're all recognizing, I think, these contradictions, these tensions within the regulations, or how they contradict what the law seems to provide, is because the parole board is trying to do something they can't actually do. They're trying to predict violence risk. It can't be done. But they're trying because California hasn't accepted that it can't be done. We think there has to be somebody to sit across a parole hearing table and predict what this person's going to do next year or in 5 years. The fact is you can't. But that's one of those sort of inconvenient truths. Like, they don't know what to do about that. So they come up with, well, if we look at it this way, if we find this still uncomfortable, that's logical. If they lack insight, they can't explain why they did what they did at 12 or 15. Never mind that he's 75 today. If he can't explain that logically, if you can't explain what you did in the past, you're likely to do it again, right? Forgetting that everything in his life has changed in the last 50 years, for example. But that's the problem. They think it's relevant, reliable, and they're trying to engage this process. Right here.
Yeah,
You give us, they can hear you.
Yeah. So my name is Raphael. Yeah, I know they used the psych report to try to predict whether you continue in the behavior that got you in. But what I wanted to ask you, Keith, was some of these factors tending to show unsuitability, it cannot be mitigated because it's all past behavior, past actions. So any one of those that are unmitigatable can keep you in there in perpetual.
It's a great point. It's a real serious problem in this process. The board often doesn't know how to get past the history, the crime, juvenile stuff, earlier life stuff. They don't know how to get past that. The courts have said, well, it's got to be something current. The ultimate reason that you deny parole has to be because they currently are a risk to public safety. So over the years, the board has increased its reliance on the psychological evaluation, what they call the comprehensive risk assessment, as a really solid piece of current evidence. A psychologist will interview you, look at all these factors, look at your history, et cetera, ask you about the crime, ask you about rule violations in prison, to try to assess whether you currently have the kind of attitude that should make them uncomfortable. And then that attitude, again, under this umbrella of insight, becomes the current evidence they'll use against you. So they will look at old stuff, they'll ask you about a 30-year-old conviction or 25-year-old rule violation, And if today you give a bad answer about it, that makes you currently dangerous. That's how they connect. We have a lot of problems with that. That's how they try to. But you're pointing to a really important thing, that these old things you can't do anything about. But the board wants to rely in some way on it. Either way. Go ahead, Sal.
Two things. One, the social history thing. For me, I wasn't a lifer, I was a long termer who qualified for
Yeah.
the 61 and I went to board. And one of my, they did a Franklin hearing on me. So they had like two psych reports on me. And they were trying to bring up that, like the board was really adamant about my relationship with my mom. So I had, because I kind of like, I was really like determined to like work on all my stuff because I do not want to get rolled over, So I went and I did a relapse prevention on my relationship with my mom. And when they saw that, they were like at the end, they were like, yeah, we knew that you had issues with your mom and that we were worried that when you got out, that was going to make you go back to prison. Like today, like I have a great relationship with my mom, but that was one of the things that they were like my whole hearing that they kept basing that on my mother, So then the other one,
Before you go, I want to talk about that one because what you're saying is, in your history, they saw there's something going on with this family relationship, something going on with relationship with your mom. You knew, oh, this is going to come up. I need to work on this. Let me figure this out. Let me address this issue before I get to the board. And you chose to address it by a relapse prevention plan. We'll talk about that. We'll talk about that a little bit today, about what that looks like. The idea is there's some problematic pattern or action or way that you operated that you want to show the board you won't be returning to in the future. How are you taking steps now to prevent returning to that problematic pattern behavior? And what you're highlighting is you developed a relapse prevention plan related to your relationship with your mother to not repeat problematic patterns you had with her before. You brought that to the parole board and they said, see, we knew that was an issue. I'm glad you addressed that. And so this is really, it brings me back to the real point of this. Although I do spend time, and we all will spend time complaining about the process. The process is not going to change today or tomorrow. They are going to be looking for these kind of connections. And if you're not making them, and if your loved ones inside are not making them, they will not be granted parole, period. So you need to be looking for, what do I need to do to make sure I'm safe when I come home? What are the precautions I need to have in place? How do I address the issues I need to address for me and for my family to be safe? You answer those questions, the board can't hurt you. But think about what you need to do for you. Identify all the areas you need to address. So that's the work we're happy to help you. Go ahead. I'm sorry, before I go, you had a second.
my other one was like, what I did notice when I went to board, like they trying to say that, like because I wasn't getting into no trouble, that I was manipulating the system. And then because they also knew my whole social history had to do with trauma, abuse, and and all these issues that I had when I was younger, they trying to like they put me down in the board. They, myself, they trying to trigger me to react a certain way in the board by challenging my, by saying that, oh, my IQ level is this, and you're stuff, like basically trying to put me down. Oh, you were a horrible person, you were this, you were that. And, and I noticed that they were doing that. They were trying to like put me down to see how I would react. And the way that I answered that, I was like, yeah, this is how I was before, but this is who I am today. So there's certain things that they do to try to get you to react, to try to trigger something in you there, because they will bring up all your abuse, all this stuff, and it's like basically re-traumatizing.
There you go. Thank you for that. And so what you're sharing is that this process is traumatizing. The board is brutal in all the ways you can imagine, forcing you to relive the worst stuff you've ever experienced. Not just the worst stuff you ever did, worst stuff that ever happened to you. And there's no real support for you in that process, unless you create it among the community inside, folks outside. And that's really a lot of what we try to do for our folks inside, to support them through that process, because it's difficult. These are the tough questions you have to be able to answer, because the board they'll let you have it. And they're trying to see how you're going to be, whether you're going to be triggered in that hearing. And then when they do, if you respond in some way, oh, I see you're getting angry. They say that out loud. That shows up on your parole hearing transcript. Anyone who sees that transcript later shows, oh, clearly she has an issue, controlling her emotions. She hasn't dealt with that issue. Parole denied, and the courts will back the parole board up on that. Those kind of things. They do that a lot. And some of them will go out of their way, even when they're going to grant parole, they'll go out of their way to ask these really inappropriate, offensive questions to get your reaction. Now, your attorney should try to step in and interrupt that if it happens, but too often they don't, for a lot of different reasons. I'm going to keep moving a little bit. There's one more hand. Go ahead. I can do a whole separate talk about that. But I will say, because, as I say, didn't do it isn't up there, this insight is a pathway home. It really is. Like I won't, some people worry I'm going to tell this long story that I usually launch into. I'm not. But I will say, Charlie knows, but I will say that saying you didn't do it, even proving you didn't do it, isn't enough. That you actually have to be able to show, I understand why I was accused of, charged with, convicted of this crime. Here's who I was and put myself in that situation. Here's how I've addressed that since then. That's a pathway home. Doesn't ever require you to admit to something you didn't do. I never advise people to do that. You don't have to. The truth usually makes more sense. That's my short version. See, Charlie, I can do it again. So I talked about the role of the courts. In 2008, there were a couple of cases that Henry Lawrence and Henry Chaputis that really helped to endorse the board's use of this insight. Before 2008, the parole board would just focus on the crime. They would spend 2 or 3 hours in a hearing talking mostly about the crime. They would look at your performance in prison. But ultimately, if they thought the crime was just something that made them too uncomfortable, or they didn't understand, or you hadn't done enough time for it, they would deny you parole. By 2008, the court said, well, that's not okay. Other courts were saying it along the way. The Supreme Court of California made it clear in 2008, saying it can't just be the crime, it has to be something else. That's where insight really gained its prominence. As here's the current stuff we're going to focus on that allows us to deny you based on the crime, but it's because you don't understand the crime. That's why it's currently dangerous. That's how it plays out. And this, some evidence, this term really means, how is a court going to review the parole board's decision? What standard of review do they use? How much evidence has to be there? How strong does the board's decision have to be? The short answer is not very strong. Some evidence is what they say. We will review the record that was before the parole board to decide whether there's any evidence that could have supported their decision. And if there was, you lose. That's it. It's the lowest standard of judicial review known. And that's what they decided applies. That was a challenge to the governor, but the same thing applies to challenges to the board. Who is the board? This is just a handful of them. There are now, I think, 21 commissioners on the board. If you go to the board's website, you can see bios on all the commissioners. Most of them have some law enforcement related background, in some capacity, as police or sheriff's deputies or prosecutors, or they used to work with the prison system, wardens. Some have been, we had social workers, we had psychologists, but they were social workers and psychologists for the prison system. So it's a little different. But for the most part, the outcomes are very similar. There are some differences. There are some who are more likely to grant parole than others. But you can read more about their backgrounds on their website. But the governor appoints them, by the way, the 3-year terms, and they get reappointed many, many times.
Is there a language that says that some of the board members should come from a certain area of, as far as not so much economic or social, so that it's more inclusive in the type of board members that are on the board?
Thank you. There's some language in the statute that basically encourages the governor to appoint people that represent a more diverse sort of cross-section of the state, in terms of their backgrounds, their expertise, racial, gender, socioeconomic status, like all these different ways that we can create ideas about a mix of people. There's not really required. It's kind of like the governor, do your best. It's kind of what the statute says. There was a bill a couple of years ago that tried to require more diversity, but it didn't make it that far, unfortunately. What else? Not much more to say about them. We can talk about them, but let's keep talking about what they do. Here's the process, the different steps in the process. The first thing is a consultation. So about 5 or 6 years before someone first becomes parole eligible, they get a consultation, meeting with parole commissioners, where they say, let's look at your file and identify the things that you've been doing wrong, the things you've been doing well, what you need to continue working on as your parole hearing comes up in the next 5 or 6 years. Those who went through the process in the past got what was called a documentation hearing. Sometimes they would do multiple documentation hearings. Every couple of years they would do one. Those weren't as helpful. The consultations are supposed to be better. The next thing is a CRA. This is what you were talking about, Rafael, which was the psychological evaluation, the comprehensive risk assessment. It is a report put together by the board's own psychologists. And usually it's about anywhere from 3 to about 5 or 6 months before the hearing, the first hearing, and subsequent hearings. The psychologists meet with you for up to an hour or longer sometimes. Sometimes it's much shorter. And they will ask you a lot of the same questions the parole board is going to ask. You got to do the same kind of work as the parole board is expecting you to have done. And the CRA will result in a prediction of risk, a low or moderate or high risk. They can now have low, moderate, high, and high risk of future violence. Again, they are doing the same thing I just said the parole commissioners can't do. Psychologists can't do it either. And they know they can't do it. But this process is intended to make them feel more secure, make them feel like there's some objective, official basis for their decision making. Document preparation, that is really about how you show the board in writing that you've done some of the work to answer the questions that they need you to answer. And some of that, and a lot of that's working with your attorney, other advocates, putting together plans for your release. So folks on the outside writing letters of support, letters that are offering housing and financial support, employment. But some of those writings are, how do I show the board my insight in my crime, for example? You might write out a statement that explains, here's why my crime happened. Here's why I did this. Here are the factors that led up to it. You might also write a letter of remorse. I'm writing a letter to the survivors of my crime, or to the victims, to say, here's how I understand I impacted you, and here's how I feel about that. You might also write out, Saul mentioned a relapse prevention plan. That's sort of a big one. People write that out to show, I've identified all those problematic behaviors and patterns that contributed to this harm that I caused. And here are the steps I've taken to make sure I never return to that pattern. And you were going to write that out. So that happens in the months, sometimes years before the parole hearing. So by the time you see the psychologist, you've got those things not just written down, but you have a real solid understanding of what's in there. Doesn't mean you memorize it. It means you understand yourself. And these are some of the tools that help you understand yourself. And then we'll talk about ways to put off the hearing. So we'll get into some of these things, what happens during the hearing, and then what happens afterwards. Cover that. So before the hearing, we'll talk about the consultation. This second one says, I'm gonna be reading, it says Olson review. And that is the process through which you get to review the file that the prison maintains about you. Has rule violations, has all the documentation of programs you participated in, classification decisions, different transfers. It also has it has some confidential information. Olson review is the opportunity for someone going through the process to know what's the board already know about me before they meet me in this hearing. What does my file say about me? What's the story the file says about me? People need to engage in this process. You need to know what's in your file. One of the earliest documents in there is the probation officer's report, which is a document that's created after the person is convicted, before they get sentenced. Probation department writes a recommendation to the court. Say, here's what you need to understand about this person when you decide how long to send them away. And here's my recommendation for how long to send them away. But it also includes a description of the crime. It says, here's what this person's role was in that crime. Here's what they say about it. So here's what the person who did this crime, how they explain their behavior. Here's more of their social history, etc. These things are deeply flawed, mostly not that accurate. Well, they have some pieces of accuracy, but the basic story about what happened in the crime and this person's role in it is based on what the prosecutor said about it. Probation officer just takes the prosecutor's file. Okay, we like that. Let's just tell this as the official version. So that's in the person's central file in the prison. So when the parole board is about to look at the hearing, that's one of the first documents they see. That's true of their psychologists. One of the first documents they see, they think they know what happened from that. And so you need to know what that says about you. Because if it's wrong, you need to try to correct it. You need to try to add to it, supplement it in some way. Doesn't mean you say, I didn't do any of that stuff, and that's the end of it. I'm not talking to you anymore. That won't work too well. But you need to know what's in there. The other thing in there is, I mentioned confidential information. There's a limit to what you can get there. But they're supposed to give you a document that at least tells you there's stuff in your confidential folder that alleges that you were engaged in some misconduct, maybe some crime. It may briefly describe what that allegation is, but that's all you get. You don't get to see the actual allegation, who made it, when, why, how, etc. I can't actually read that next thing. What does it say? Oh, appointment of counsel. So about, I guess, between 4 and 6 months before the hearing, the board will appoint an attorney if you haven't already found one. About 90% of people going through this process have a state-appointed attorney. The rest either have someone from common law or one of the other organizations. There are a lot of organizations that do this. There are a lot of private, a handful of private attorneys who can be hired to represent people in their hearings. We have 10 attorneys in uncommon law, but all our hearings, we represent people pro bono. You can't hire us, but it also means we can't be everywhere. So a lot of people go through and they have a state-appointed attorney. That attorney is supposed to help do all the work we've been talking about today. And then we have a session later about how to work with that attorney. And what's that last one? We better ask them what the last box is.
CRA.
That's the CRA? Okay, I'll trust you, Tony. All right, we covered that already. Thanks. This is more about the CRA stuff I just covered. This last part here, it says CRAs are good for 3 years. That just means the parole board's not going to give you another one. If your most recent CRA, the most recent prediction of your violence risk, is 3 years old or younger. If they've seen you less than 3 years ago, they won't give you a new one. Generally speaking, there are a few exceptions, but not many. This talks a little bit about the risk assessment tools they use. The report itself is like a 10 or 12 up to like 20-page document. They use a couple of tools in making their risk prediction, but as Raphael said, some of those are heavily weighted towards historical stuff you can't change. So some of those risk prediction tools, when you punch in the numbers, it automatically elevates a risk based on stuff you can't actually change. They've improved over the years so that they include your current statements. They consider that like dynamic information, things that can change from one hearing to the next. They think that gives them a more accurate prediction.
Can someone site?
Oh, great question. Can you get your own psychologist to do an evaluation, do a risk assessment? You can. Almost all the time when you do that, it's wasted money. Because the parole board doesn't have to give it any weight at all. Then courts back them up on this. No, the parole board has their own expert. They look at it the way they do it. We're not going to make them give your report any weight. What I will say is where we find it really helpful to bring in your own therapist, your own clinician, is to provide therapy, to provide counseling. When either we recognize, or there's a gap in someone's understanding, or we see the board has recognized it for years, say, oh, you're not addressing this issue, et cetera. We will sometimes bring in a therapist from the outside. We have some on our staff, actually, whose job is to help fill those gaps, provide months, sometimes years of counseling therapy for some of our clients to address those gaps. That's the best way to use outside clinicians. It's not, and then it's, here's additional programming, treatment, therapy this person engaged in. Not, here's an expert to compete with their expert. It's a different way. Somebody else, I'll come back to you right there first.
That a moderate high CRA is now being treated the same as a high, in that it's not, if you have a moderate high, you're not eligible for administrative review if you get through that. You know, that's accurate.
Thank you for that question. The question is, with this change to moderate high, to low, moderate, high, does that keep people who get moderate high risk assessment from advancing their next year? We're going to talk about the process for advancing in a minute, but I don't know how they do moderate high. I know moderate is something that used to go either way. High, if you have a high risk on your last risk assessment, they're not going to advance your next hearing, at least not on their own. You can still petition to advance. We'll talk about that process in a minute. But I don't know whether moderate high are. Anybody have a better sense? Rebecca, you know? So what she said is the regulations cover this moderate sort of situation, but it doesn't cover moderate high. The regulations were written before they switched to low, moderate high. And so if they are implementing a ban when it comes to moderate high, that would not be consistent with the regulation, which doesn't mean they're not doing it. We'll talk about what this means as we want to give a little more context for this. You had one more thing.
Yes. The prison system has a mental health department program, and what's encouraged, from my experience, is to get involved with the psych program in the prison that you're in, and have their not only assistance therapy, but have their reports be a part of your next board hearing. In other words, the Triple CMS program is not necessarily for someone who is mentally ill, but for someone who's seeking therapy and seeking support from the mental health And it was very instrumental in my hearing to have that as part of my parole board hearing.
Thanks, Ed. You touched on a really important piece to this process, really within the prison system more broadly. There is a mental health program, we refer to as triple CMS, as Correctional Clinical Case Management Services. And it is the lowest formal level of mental health treatment. Not everybody there's on medication, some are. You see a clinician about every 90 days or so. And sometimes you may have access to some kind of group therapy, usually not a lot. And then there's a higher level, enhanced outpatient program, EOP, more intensive treatment, more one-on-one with therapists. So many people engage in that kind of therapy at either of those levels, or even there are higher levels we talk about. One thing that is concerning about that and about people who are involved in substance use therapy, especially medication-assisted therapy, that those treatment records, the board gets access to. And while for you it was helpful that they could see, oh, he's engaged in therapy and that's helping him, for some people, they use that against them to say, oh, this shows you're still unstable. This has a concern that you're not complying with medication, or people who are receiving the substance use treatment. They're saying, oh, the records show that you had a dirty test, that you relapsed. Now, you never got a rule violation report for relapse. No one ever found that you relapsed. And maybe you didn't, but someone on your treatment team made a note, oh, he relapsed. The parole board will use that against you. So they should, to be clear about it. I think we need to continue doing everything we can to encourage people to participate in meaningful therapy when they can get it. Absolutely. And we should be doing everything we can to prevent the board from using that. We don't want to discourage folks from engaging in meaningful therapy. We just don't want to. Too many lives have been lost because people don't ask for the help that may be available. So it's a tension in this process. There was another hand up. Oh, go ahead. Okay, how does your housing during incarceration affect your CRA? Well, I would say, I'll put it, it's not just the risk assessment that's affected by your housing. The whole parole process is affected. For example, there are some facilities in this state where those facilities go years without a single parole grant. Years. Hundreds of people going to the parole board. Nobody gets granted. The parole board knows that. The psychologists know that. People who work there and the people who live there know that. So the expectation is, well, this is a place there's not a lot of programs. There's a lot of violence, a lot of 115s. It's a higher security level. So if people are at this prison, I expect them to be involved in some negative behavior. Yeah. I'm expecting them to be involved in negative behavior. So that expectation sort of is all over that particular facility. So their psychologists have the same expectations, same bias really. Even on some, I was just talking about where'd this come up? Oh yes, it's just this week that sometimes at a particular prison, there are multiple facilities or yards at each prison. And two different facilities at the same prison may be treated very, very differently. Some people on one yard, maybe on the honor yard, get all the programs. Someone on the yard next to that gets no programs, or very few. Parole board knows that, folks there know that. So the expectations are based on where is she coming from? Oh, she's from that yard. She might be in program. She may be doing the right stuff. If she's in the general population, I don't think so. She must be up to no good. She's still gang banging, whatever it happens to be. Like those attitudes show up in the psychologist's report and in the board's perception.
I was wondering, are they still in your evaluation
This is the question about whether they are still diagnosing people with antisocial personality disorder. The short answer is yes, they are. Because that diagnosis doesn't really, there's not a whole lot you can do about it. It doesn't take much to get that diagnosis. The fact that you committed something that resulted in a life sentence, pretty serious, it's all off the violence against someone. And oftentimes, if you explain, well, I started kind of getting trouble when I was younger, that's really all it takes. Those two things, conduct disorder that started before age 15, getting in trouble, whatever it happened to be, and some other kind of manifestation like the commitment offense, life crime, that's about all they need to apply that label. So while they do it all the time, because they do it all the time, it kind of has lost its significance. The parole commissioners know there's nothing you can do about that. So I don't think they give as much weight to that as people fear that they would. It was one of the, go ahead.
One of the things that I noticed that they said to me was, I got a 128 when back in 2010, right? So by the time I went to board 2020, I had no write-ups at all. They were trying to say that I was trying to manipulate the system, that I was doing things and getting away with it, and that I was trying to manipulate the system, that how come I have this all this game background, and all of a sudden I start getting in trouble. And I have officers writing me chronos and stuff that I'm manipulating staff to write me chronos. And, so that's one thing that they bring up a lot about the manipulating the system.
Yeah. So what you're describing is basically she's saying she was too good, too perfect, not getting in enough trouble. The pro board gets suspicious about it. Like that's kind of ironic, right? Like this is what I also see is people whose crime is really like almost like out of left field, like something completely not consistent with their lifestyle, something happened that they didn't have sort of a pattern of behavior that led up to some violence, resulted in a life sentence, and they're in prison. Those folks have the hardest time proving to the court that they're safe to be released, even if they have a clean disciplinary record. They say, well, the fact that you've been clean for 20 years doesn't help us because you were clean before you committed this crime. You were just unpredictable then, and you're just as unpredictable now. Some people used to advise folks going to prison, mess up when you get there. Get it? Some people recognize this advice, some people got this advice, some people given this advice. Mess up when you get there so that you can show you changed over time. But there's something to that change narrative, right? They want to know that you were some kind of way. You did work to change your life, and we can follow that change. If they can't follow the change, they won't feel comfortable granting you parole. Whatever that happens to be, whether it's used to be violent gangs, drugs, violence, crime, whatever it is, you've got to be able to explain to them. They have to understand how and why and when you changed. Go ahead.
So I have a life without parole. I did not have a doc hearing. I didn't do any of those. I was also disciplinary free for 20 years. So I was commuted by the governor. I went, you guys represented me. They asked me the question. They said, so it looks like you've been, you've been programming, you've been doing all this. Have you done anything that would have resulted in a RBI?
Anything you didn't get caught for?
I said, absolutely. I absolutely did. I drank, I smoked weed, and then I got it together. Yes, I did. And then they moved right on. They didn't say anything about it. I just admitted it. I told on myself, I tattooed, all that. Moved on.
Yeah, your attorney's like, okay, all right. So she's sharing an example of what the change narrative can look like. On paper, you might be clean, but they also know that when you come into prison, there's a lot of expectations, a lot of pressure, a lot of fear, all that stuff. And your actions are consistent with somebody who's afraid, trying to figure out how to survive in this place. And so they don't really hold that against you unless you lie about it to them. A lot of people lie about it. if they knew I did that, oh, they'd never forget it. It's not true, because that change there makes a difference. And you acknowledging those things made you credible. And a lot of this is about credibility. What are you willing to admit about yourself? The good, the bad, the ugly. So that they can say, well, this person's telling the truth. This is somebody this is a change we can believe in. Go ahead.
I couldn't see it, because I would have fell off myself. I was
Mm,
like, no, I didn't do it. Well, still get it. So when they got to my first 15, and I had so many of these, I started being honest. Yes, I could, because I was scared. Or maybe because I didn't want to live, be a part of because this. And I started being honest, and then I thought, what made you change? See, everybody else go home before me.
Mhm.
I'm already here 20-something years, and I got people coming in with 5 years, and they're going.
Yeah.
So I decided to start changing and start educating myself, and they started looking at it, and they didn't really count me for it. They were like, okay, we see the difference in you now coming in at 17 years old.
yeah. Offering another example of what telling the truth can get you. And including telling the truth on yourself. Stuff you didn't have to tell. Stuff you lied about before. You can tell the truth. And it works. It works not because it's manipulative, but because it's the truth. Because it's genuine. They can see your change is like authentic, it's real. It actually does communicate. And one thing I often say is about the thing about the game of this process, it's not a game. Alicia, you had your hand up earlier and I missed it. I'm sorry. Right. Okay. Okay. Repeat the question about whether the board has a sense of like the reputation that different yards prisons have in terms of people's access to programs, politics, controlling that. Rebecca, you had some? Mm.
How do those controls determine whether you encourage your clients to try to observe out, because they might have better programming opportunities, and how to deal with the conflict that I see, where people in prison don't necessarily want to go to the church or pray. And I understand why, but I also see some potential in there.
So this question is about the non-designated program facilities. These are prisons that the state has decided, we're going to decide some institutions, we're not going to say these are general population and these are what they used to call sensitive needs yards. Instead, we're going to say some places you're just there to program. We're going to run programs and we're not going to designate them as general population or SNY. We're going to send everybody there who says they're going to program. We're going to expect them to program, including program with people that are on their enemy list, people who have come from more violent or more sensitive places. We're going to mix everybody together. Sometimes people have been decades in a sensitive needs yard because they dropped out of a gang or they're former law enforcement on the street or something like that. Or they told on someone in a crime. We're going to put them on the same yard with people who've always been in the general population yards. And traditionally, those two don't mix. They've said, we've created these non-designated programming facilities. People's going to program. And that's where the state has invested more in programs being available. So if the board says, we want to know you're doing the work you need to do in order to come home. You're learning how to get along with people who are not like you, people you don't like. You're learning to participate in programs that are available to you. That's the board's view of it. I have a lot of problems with that. A lot of people do. But that is what it is right now. I think it's important that we get access to programs at all the yards, because there's some people who will never go to one of the yards. Or if they're forced to go there, they will immediately attack somebody so they can get out of it. So I never agreed to mix with people like that, right? It's a mess. It's a real mess. I don't have any great advice. I mean, part of it is when we see people who are not at a prison that has access to the most meaningful programs, we kind of supplement. That's some of what we do. But nobody who can do that, who has the resources to build it. I'm gonna go over here, and we're gonna keep moving.
Say, like, for the woman, it's not the same in prison as the men.
Mhm.
You know, like, the woman just get put anywhere, and you have no say-so into where you get put. Sometimes if you want to go to the honor board, you have to have a certain qualification, and sometimes it might take years for a person to be able to move into the honor board. Sometimes the staff want to, they don't want to, like, help you move from one yard to another. So you gotta basically make the best out of it by getting involved in groups and different activities and stuff that are there. But they just put anybody anywhere. You have no say so who they put in your room, or but none of the yards are programming yards. It's just anybody. The only housing units that are like designated, you have to be 2 years right free or
Mhm.
and even then, because the cop says, "Oh, you used to be a troublemaker. I don't want to move you in there." They don't move you in there because they think that they know who you are now.
You make a really important point. You have very little control over where you go, where they put you. Right? But what does the board want to know? They want to know, what did you do about it? Did you say, I got to go to the board, but I'm stuck here, so I can't access the programs that others might want? I'll just tell the board that. Tried, but couldn't get into it. Doesn't go over too well. They want to know, what did you do in the meantime? Book reports. I mean, there are a lot of things that people can do while they can't access the more formal programs. Correspondence courses are one. Book reports. And to be clear, a book report is not really a report about the book. It's about what I learned about myself from reading this book. The workbook, any kind of guide, any kind of book that you find meaningful, helpful in your transformation, you can write about it. Reflect on it, write that down. Document your progress. You can create groups of your own. Most of the best groups in the state were created by folks inside because they needed it and wanted to support each other in this journey. It wasn't created by someone on the outside necessarily. So you have to show the parole board you were doing all you can to do. I got to go on. Sorry, but the board wants to see that you are trying, not saying, "Well, I can't, I couldn't get access to it." To be clear, I don't think that's fair. I don't think they should be penalizing you for not participating in programs that you couldn't actually get into for whatever reason. But that's just how it's going to be for right now. We gotta move on this slide for like 20 minutes. We're not even halfway through this question now. We're wrapping up. We talked about some of these ways of preparing for the hearing. Relapse prevention plan. We talked about what that was a little bit. It doesn't have to be big, thick, extensive. It has to be personal. It has to be yours. How is it that you stay on this path? What are the things you need to look out for to make sure you stay on the path? We'll talk about parole plans, letters of support, and some of the other writings. Let's go back and spend just a minute. The parole plans. Think about what does that mean? That's going to be the next session. Okay, well, 2 sessions. All right. Well, these are just some of the things you'll have to do. My quick note about parole plans is think about it as you're needing to paint for the board the clearest picture of what your life will look like after this. Where you're going to live, how you're going to work, how you're going to support yourself, how you're going to continue like the emotional work that you've been doing since you were inside, how you're going to reconnect with family. These are some of the other things that you need to develop for preparation for your hearing. You talked about those. Inside, you talked about that. Why would you ever put off your hearing? Been waiting all these years to get a chance to go to the board. Why would I put it off? Well, Sometimes, we said you could be denied parole up to 15 years. If you got a long denial on the horizon, you might say, you know what? Maybe I'll take some time to improve my chances when I go. So let me not go. There are a couple of ways that can happen. The hearing can be taken off. It can be postponed. We can sometimes request it, but not usually. We can request it, but it'll be denied, unless we have a really, really good reason. Sometimes if we have the person we work with has a petition pending in court or some other kind of court action while their parole hearing is coming up, sometimes that'll be a reason the parole board will agree to postpone the hearing. Other times because somebody gets sick, commissioner becomes unavailable, something like that. They'll postpone the hearing. Typically, when they postpone it, it puts it off 4 to 6 months on average. A waiver is one of the few ways that puts a little more control in the hands of the person appearing for parole. I know I have a right to go to this hearing today or this month or in 3 months, but I want to put that off. I want to put it off 1 year, 2 years, 3, 4, or 5 years. You get to choose. And you may do that to give yourself more time to complete the program. Maybe you got an appeal pending that you want to deal with. You get to say, I want to waive my hearing 2 years. And whatever reason you have for that, it's up to you. The board has to grant it as long as you make that request at least 45 days before the hearing. If you miss that 45 days, then they're going to say, now we're going to go through this hearing. And if you want to take it off the calendar at that point, you have to stipulate. Stipulation is saying, I admit to being unsuitable for parole. And I will be for 3, 5, 7, 10, or 15 years. People stipulate sometimes 10 years, 15 years. I've given up. I don't want to see y'all again. Don't bother. It's rare, very rare, but it happens. More common is a 3 or sometimes a 5, but it's an offer to stipulate. I don't want to go. I'm going to stipulate. I'm offering to stipulate to a 3-year denial. Well, I'm looking at your 115s, your rule violation reports. You got too many of them. 3 is not enough. It's like almost a negotiation. Give us 5 years. Stipulate the 5 years, or we're going through with this hearing. The implication is we're going to hit you with something worse. So you better take this 5 and like it. But this petition to advance, I want to talk about because it comes up a couple of different places. If you get denied any length of time, you can petition to advance your next hearing by showing some change in circumstances or new information. It says, I don't need that original 3-year, 5-year, 7-year denial you gave me. Things have changed. I finished that program. I got rid of that 115, etc. I no longer need that much time to file a petition. The board can say, okay, we think we should at least look at you again. You've done the thing. You've stayed out of trouble long enough. You've mostly responded to what we recommended. Let's bring you back sooner. You can do that on a stipulation. Stipulate the 5 years. You'll petition to advance. They may bring you back in 3 years. Stipulate the 3 years. You could come back earlier than that. You can't petition to advance on a waiver because a waiver is not a denial. You can only advance following a denial of parole. So that's one thing to think about. But a waiver doesn't mean I'm saying I'm unsuitable. So there's a lot of reasons you should do a waiver and not a stipulation. You should pretty much never do a stipulation if you can avoid it. The waiver, in addition to the 45-day limitation, you also can only waive a maximum of 3 times in a row. People do that. They waive this year. Here it comes up next year. I'm going to waive again. Once you've done that 3 times, you have to either go through with the hearing the next time or stipulate it. And then that starts over. Some people will do that over and over. Let's keep moving. The different types of hearings, we've touched on some of these. What we've mostly been describing are maybe they're considered normal parole hearings. But while there are these other categories of people who get youth parole hearings, elderly parole hearings, medical parole hearings is a slightly different thing. Hearings for people who are survivors of intimate partner battering and its effects, third strikers, those are all basically the same hearing. There's different language that the parole board will use and introduce you to the hearing, explain, here's why we're here, because you qualify for elderly parole. Or we're here because you qualify for youth parole, or both. There's somebody who was convicted at age 15, they're now 65. They qualify for both youth parole and elderly parole. So the board will use that language, but the hearing itself is conducted in pretty much the same way. It's the same commissioners, same questions, same factors. There's some regulations that require them to give more weight to certain things. The fact that you were young and you have since changed is supposed to be getting more weight in a youth parole hearing. The fact that you're older and may have medical and other challenges is supposed to make it more likely to grant a parole under the elderly parole. But in practice, the parole grant rates for all of these hearings are about the same. Still very low. So some of these were driven by court decisions. Others were driven by legislation that is supposed to be pushing the board toward granting more people. But in practice, it usually plays out that more people are having parole hearings, but the rate at which they're granted is not really making a difference. I mentioned medical parole. This is if someone is medically incapacitated. There's a process to consider transferring them out of prison and into the community for like 24-hour skilled nursing facility placement. The downside is if they get better, they get sent back to prison. Believe it or not. But it's also not regular parole. While you're out in the community on medical parole, you continue to have regular parole consideration hearings. It's a mess. We can talk more about that, but I want to keep us moving. All right, during the hearing, this just lays out the areas that they talk about during the hearing. In the exchange with the commissioners, hearings last on average nowadays about 2 hours. Some go barely an hour nowadays. They used to be much longer, but they all cover the same material for the most part. They talk about the life before the crime. They talk about the crime itself, what you did, who was hurt, and how, and why. Post convictions, everything you've been doing since you've been in prison. And they talk about your parole plans. We'll spend more about that time on that later. Who's there? While you have an attorney, the attorney gets to ask you questions, but if the DA has a representative there, they get to ask questions also. And there's supposed to be some limitations on their questions. They're not really supposed to be asking the parole applicant, they're supposed to be asking the board to clarify this issue that I saw on the record. But if I'm the attorney, I also get to ask my client questions. There really aren't that many limitations on what I ask. There's a closing where each person gets to make their argument about whether the person is suitable or not. They will sometimes try to limit how much time the attorney gets to speak to 10 minutes. There are people who like to take much longer than that, you can imagine that. The person who's appearing for parole gets to make their argument. They'll call it a closing statement. Why do you think you're suitable for parole? A lot of people overlook this opportunity to not just like, I want to say make their plea, but it's really about what is the thing that the board needs before they go and deliberate? What do they need to hear from me? And my recommendation is they need to hear that you show some understanding of the harm that you caused. And that you end by expressing some remorse, some acknowledgement of remorse for that harm. It's not, your closing is not your opportunity to say, here's how much I've changed in the 20 years I've been here. Here are the programs I've participated in. Here's why I'm a good person going forward. Here's my parole plans. It's not the time for that. You've already done that through the rest of the hearing. But also people should write it down. Write it down, write it down. Write out your closing is my recommendation. People say, I just want to come from the heart. Don't do that. I just want to go with how I feel in the moment. Don't do that. Don't trust it. Because you'll be rambling. You won't say what you need to say. They won't hear what they need to hear. You will miss an opportunity. Rarely does that work well. To just, I just want to go with the feeling of the moment. Don't do that. Don't do that. That's my strong recommendation. It should not be long. Keep it short. And the family members of the victim in your crime, they get to come to the parole hearing. And if they come, they get to speak. There aren't that many limitations on what they can talk about. It's supposed to be about, what do we think about this person who's appeared for parole? What would you like to share about the impact this crime had on you? It's supposed to be about that, but the parole board often does not impose real limitations on them. Sometimes family members will make some pretty wild allegations and accusations about the person, about past conduct, about current, he's still trying to get our phone number, or they're trying to contact, like stuff that nobody can prove, there's no formal allegation, but it infects the board's view of that person in that hearing. Again, there are no real limitations on how long they can talk either. Sometimes the family members talk longer than the rest of the hearing takes place. And the decision, they'll tell you right there at the end of the hearing whether they're going to grant or deny. What does the board need to see? We've talked about the role of insight nowadays. Who were you at the time? How did you come to be that way? And how have you changed since then while you've been incarcerated? To satisfy the board, you're no longer an unreasonable risk to public safety. They are looking for, not just for them to see the patterns, they're looking for you to see the patterns. They want to see how you connect the dots between the things that happened in your life, happened to you, happened around you, what you internalized about those things, and how those were the character traits or habits, practices, beliefs showed up in different parts of your life. How they showed up before the crime, how they showed up in the life crime, how they showed up in rule violations and other activities in prison, and then how you've addressed them so that going forward, you'll be a safe bet for release. Show us you've done it. Show us you've connected the dots and then severed the connection between who you were then, how you were then, to who and how you will be going forward. Go ahead. You gotta be quick. Run out of time.
One of the most important factors is a victim's impact statement, but also an offender impact statement. Understanding that speaks volumes to the board that you know why you're in that hearing.
Absolutely, absolutely right. The presence of victims, their family members, has a really significant impact on the outcome of the hearing. Statistically, that's true. Emotionally, experientially, that's true. It has a really important impact on everybody in the room by design. But also, the board is looking to see, well, how genuine are you in sharing your journey with them? If you're in there trying to sort of strategize and manipulate, it will not go well. What else? What happens after the hearing? Well, if you get a grant, there's a 120 days of review after the hearing. In that period, the board could take another look at it. They can conduct an en banc review, they call it, or they can just affirm it. And if it's a murder case, then that parole grant decision then goes to the governor. It's another 30 days to decide whether or not to reverse that decision. If the governor leaves it alone, the person comes home at least at their earliest, their minimum eligible parole date. So if you get a parole grant your first time, at your first hearing, your eligibility, your parole release date hasn't arrived yet. Because your first hearing takes place up to a year before you're actually eligible to be released. So you might have some months to wait. Again, it doesn't usually happen to people granted at their first hearing. If you're denied, as I've said, 3 to 15 years, and there's still a review period. Sometimes you can informally challenge the board's decision, say, oh, they messed this up, they broke the law when they conducted my hearing and improperly denied me. The board may take another look at that. We have materials on how to like, challenge informally a bank parole decision and ask for a change. We talked about the petition to advance. We talked about this We talked about the petition to advance, but this other thing we haven't talked about is an administrative review. It's kind of like, it's like a petition to advance on a 3-year denial that you don't actually have to file. The board does its own review about 11 months after they deny you 3 years, as long as you got a low risk, maybe on a moderate risk. Right. Maybe moderate to maybe, not if you got a high risk in there. They may advance your hearing on their own. All right, I've allowed you to ask questions along, so I hope you don't have a lot more right now because I'm out of time. But I see one, I'm gonna take one if it's gonna be quick. Okay, it's very quick. Okay, the Olson review, is that what you're asking? Okay, she's asking about when do you get access to your file? When can you do an Olson review? The Olson review is just about recognizing your right as an incarcerated person to have access to your prison file. You have that really every year, any year, once a year you can do that. Contact your correction counselor, hey, I want to do an Olson review. And they have to let you see it, and they have to give you copies of anything in there that you want, except for the confidential stuff. But even as to the confidential stuff, they have to give you a page that really roughly describes that there's material in your confidential file. So you can try to challenge it. It's very difficult. We can talk about challenges another time. I'm out of time for this section. I think we're going to do a mock hearing next, and then we're going to have a break. Should we do a quick 3-5 minute break? What do you got there? What do you say? Huh? Very even better. 15 minutes. We'll come back to a mock hearing. Thanks, folks.
3 years.
Yeah. You want to play participant?
You'll never.
Which spot? Who are you? You know?
Want me to go grab? Great, you two does, this up perfect.
I knew all this already. Still good though. Yeah. Like the interaction, questions. A lot of questions that people have not had to go through. Yeah. Go through that. It's also, something that Don and I have been through. Oh, yes? Blueprint.
All right, we are going to get started.
Inside is important. Very, very important. It's like beyond the board. Right? Absolutely. And you gotta live it. No.
It's no fire, it's not long enough to use it. But,
All right. Good morning, afternoon to you all. My name is Emma Tolman. I am a staff attorney at Uncommon Law. I personally wear a few hats. I am the staff attorney for our Home After Harm program, which is an in-prison program that we run. I work with all of these people. We're all part of the same program, where we provide like a therapeutic space and parole preparation for people at Salinas Valley and Lancaster's prisons. And I'm here today to sort of talk a little, or we're all here today to sort of give you a little window into what a parole hearing looks like and feels like. But just like everything about Uncommon Law, we're going to do it in a very uncommon way. So before we get started, and I'll tell you a little bit more about what's going to happen, I'm going to have my esteemed colleagues introduce themselves.
My name's C. I was formerly incarcerated. I came home December 2020. I've done many of these mock hearings inside, so it's really a stressful moment for even the person sitting on the other side. So we're here to support Charlie, right, and Warren and the whole team up here. So yeah, Warren. Oh, I was a former legal assistant for Uncommon Law as well. So these are colleagues, great people, and an amazing team that we have there. So yeah.
Good morning, everybody. My name is Warren. I'm a parole success advocate with Uncommon Law. I work in the Home After Harm division of the organization with Charlie and Emma, Jasmine, Israel, and some other people. Me and Charlie, we work in Salinas Valley. We go in there 2 nights a week on Tuesdays and Fridays, and it's really special to go into a place. I resided inside the Department of Corrections for 32 years. I was released January of this year, so I'm not actually a year from my incarceration. So to go back in there and deliver a message of hope to a bunch of people that I left behind is an important thing for me. And it's part of the work that I intended to do when I paroled and I said I was going to do. And some of the people that I encounter are still on the 4-yard 32 years later. And Keith spoke about the non-designated program facility title, and there's a lot of things in a psychology that's wrapped up in who I am as an individual if I go to one of them yards. And so there's a lot of things that are encapsulated within that question. And so for your loved ones and the people that you support and you care about, if it's more important for them to hold on to a prison identity than it is for them to get home, then you need to have a more broader conversation with your family member. Because the door is open, it's possible, and it's only through doing this kind of work. And we're one of the only programs where in Lancaster on that yard, general population yard, and we're in Salinas Valley on the general population yard that exists there. For a lot of the people that are in me and Charlie's group, it's the first deep diving program they've ever participated in. And so to sit for the first time and understand their feelings and emotions and talk about deep childhood traumas that they never experienced with anybody takes such an undertaking of risk and challenge. And we try to explain to them every night that vulnerability is a strength, not a weakness. And it's getting around that ideology that's actually the first step to their growth and development. And so I'm definitely appreciative of Charlie, because I know me and C didn't want to sit in the hot seat. And so we outvoted him. And so Charlie's gonna play the participant in the hot seat today. And so I'm very glad for Charlie being here.
Hello, everybody. I'm Charlie. I'm a parole success advocate with Uncommon Law, as Warren said. Can't really follow that up, but can speak a little bit about my nerves right now. It's been a long time since I've done a mock hearing or even felt like sitting across the table and like being in the space. Brings back a lot of emotion of going through the parole hearing and the trauma that happens and occurs through those hearings. It's really weird, right? Like Warren mentioned it, but to be inside with the guys and be in the circle, this feels completely different, right? To be out here doing it, like in there with them, it's home. It's where I spent 22 years of my life and where I grew up. And as Warren said, learn to be vulnerable with people that on the inside, most of society doesn't think can be that. So here we go, and I'm not going to say too much more because you're going to learn about me, I guess.
All right. So like I said, well, who here's been to a parole hearing, either as an observer or as a participant? Oh, so many people. Okay. This is wonderful. So I want everyone who hasn't been to a parole hearing to know this is not what a parole hearing looks like. What we're doing today is a little interactive activity where we are going to sort of throw out some questions from the commissioner to Charlie. And Charlie is going to give an answer, a perfectly good, fine answer that someone might respond to in a parole hearing. And then this is the part where things get really different. Charlie's going to have an opportunity we're going to like put this sort of demonstration on pause, and Charlie's going to get to phone a friend. And those friends are all of you sitting in the audience. And you and you all are going to offer some feedback based on Keith's presentation, based on what you already know about the parole process. And you're going to give some input into what Charlie could do to improve his answer to get closer to parole suitability. As we all know, parole suitability is not guaranteed, even for the most like incredible, inspirational, reflective, transformed person. But what I want you all to do is to provide Charlie some feedback, and then we're going to roll the tapes, or we're going to rewind the tapes, and then Charlie's going to get another crack at it. The commissioners are going to ask the same question, And Charlie's going to see if he can incorporate some of your feedback into his second answer. All right. So you all are just as, maybe not just as in it as Charlie, but so when you're listening to Charlie's responses, think about, is this accountable? Is this showing insight? And is this showing remorse? All the things that sort of Keith was discussing are important to show in a parole hearing. Any questions before we begin? Any questions from you all?
Make it easy on me, you all.
All right. Over to you, Commissioner Dang.
Today's December 2nd, 2023, it's approximately 11:28.
You all need a little context going into this parole hearing. You're like, who is this man? You've just heard a little bit about who he is today. So Charlie's really graciously offered at least like as much of a story as he's comfortable with today. So it's my job to give you a little context about who he is and what some of the commissioners are going to know going in. So Charlie was convicted of first-degree murder and second-degree robbery. Charlie and his co-defendant named Thomas planned to rob the victim, in this case, David, for $1,000. David was coming over to Charlie's house, and David planned to beat him up and take his money. Charlie went into his mom's bedroom to grab her gun, handed it to Thomas. David showed up, and the three of them went into Charlie's bedroom. Charlie went to the bathroom. A few minutes later, Thomas, his co-defendant, came into the bathroom saying, I shot him. I grabbed the gun and I shot him. So that's the context of sort of where this parole hearing is coming from. Thank you. Over to you again, Mr. Dang.
Take two. All right. Today, December 2nd, 2023 is approximately 11:29. We're here at San Quentin State Prison. This is Mr. Spence' first subsequent hearing. For the record, we will say our name, then we spell our last name. For you, Mr. Spence, please include your CDCR number. My name is C. Dang, D-A-N-G.
Present for this hearing is Deputy Commissioner Warren Hands, H-A-N-D-S.
Charles Spence, S-P-E-N-C-E, P10874.
We are here not to retry your case. What we find, court finding is facts. Do you understand that, Mr. Spence? Okay, we're going to swear you in. Please raise your right hand. Do you solemnly tell the truth, the whole truth, but nothing but the truth? Okay, thank you, sir. Okay, I'm going to ask questions about your pre-commitment crimes and your crime. You understand that? Okay. So I see that in your CRA, you mentioned and state that the gun belonged to your mom. Is that correct? Okay. So what was your relationship looks like between you and your mom growing up?
My relationship with my mom was okay. She loved me and my brothers. She was a hard worker. I was her favorite child. I pretty much got everything I wanted from her when I asked her. She went to all my sports games and was always there for me. So I think the relationship was pretty good.
All right, thank you. All right, anyone in the audience have some feedback about that answer? All right, let's hear it.
It doesn't really give any depth or anything. You don't really get a sense of relationship or how that might affect his time or what happened.
Okay, so I'm just going to repeat for the people on live stream. There wasn't a lot of depth and there was not a connection between sort of how that relationship may have led to the life crime. Thank you. Any other feedback? I think I saw one other hand.
It seemed like he was putting a real positive spin on his relationship with his mom and putting it in as like possible.
Okay. And what might be some feedback about how the board might interpret that?
I think the board will see a lot backwards, how the life is good and the bad. And I think, especially with the question about parents, it can be hard to talk negatively about a parent, especially if they're gone from this earth or if they're still here. I mean,
either way. And I think the board wants to see people be able to reflect honestly about their history. And so if they had a negative experience growing up, they can't spin it in a positive light and be honest with the team.
Okay, so the board's really looking for like honesty and sort of deep self-reflection into some of the things that led to the life crime, that led to some of the behavior patterns in someone's life. And just glossing over, maybe only talking about the positive, maybe indicates that the person hasn't engaged in some of that self-reflection. Okay, thank you. Yeah.
Where he said, oh, it was okay, like, and when he started saying about, oh, you know, like she was there and all that stuff, they could say, with the beginning of, oh, it was okay, that he's minimizing it and that he's still in denial about how his childhood upbringing was.
Okay, so that maybe it indicates that saying it's okay might indicate that he's still in denial, that he hasn't done some of this deep thinking that's necessary to show the board. Okay, I'll go over here. Yeah. Yes, that's correct. Right. So what are you like? What might a connection be that you're looking for?
Critical analysis of the family dynamic and relationship, particularly with his mother, especially the growth within this time.
Okay.
The growth from the period of the upbringing was good, and then her weapon was used, and then what is the growth from there?
Okay. So sort of a key missing element was, the question was, I see you use your mom's gun for the crime. And that sort of piece was left out of his response. So there might be some connection there that he'd want to include in an answer. And perhaps at least if not in this question, a different time in the hearing, he will likely have to explain sort of how his relationship with his mom is today, especially if there's still maybe firearms involved. Okay. One last comment, and then we'll see how Charlie incorporates all of this. Yeah.
Yeah, the question was about the relationship with the mother, and we heard about the mother, but we didn't really hear about the relationship. And so I would have been interested to hear how you felt about it, and maybe you took advantage of her generosity, and that might connect back to your life story.
Okay.
Y'all are too smart.
Yeah, you all are really good at this. I think that's a really key piece, that there wasn't a connection between sort of the relationship and then the behavior patterns that he developed, like in response to this. So did he take advantage of it? How did he take advantage of this relationship where maybe he was the favorite and got to do what he wanted? All right, Charlie, do you feel like more equipped for the second round?
No.
All right, back over to you, Commissioner.
Mr. Spence, in your CRA, you state that the gun belonged to your mother, is that correct? Right. What was your relationship like with your mother growing up?
Well, I knew my mom loved me growing up. She was rarely around. She was a correctional officer, and she worked inside of the prison system. And she was trying to raise 3 boys. So I have a younger brother and an older brother, Commissioner. And she was just never around. And when she was home, she would go to her room. So she wasn't even present when she was there. And our relationship really had no boundaries. I was able to do whatever I wanted. And when she came home, she would go straight to her room. And I took advantage of that. And she didn't seem to care about the negative behavior that I was displaying at that time. And that kind of gave me the freedom to do whatever I wanted to do. So when it came to that moment, going into her bedroom and getting the gun, I wasn't worried about what she would think or what the consequences of that would be. Because at that time, our relationship was more like an unhealthy friendship than it was a parent-child relationship.
All right, how do you do? Any reflections on just hearing that? Yeah.
His mother's job really changes the perspective. I didn't know this was
Okay, so it gives some more context into like maybe why there was a gun, how that impacted Charlie. Yeah.
I think citing that it wasn't a healthy parent-child dynamic, it was more of a friend dynamic, emphasizes that like he knows what a healthy dynamic should look like, and that
Yeah.
he can identify that that wasn't.
Okay, yeah, identifying that it wasn't a healthy parent-child relationship shows that he's done some of this reflection work and now he knows like the relationship maybe he should have either with his parent today or maybe as like a father himself. Great point, Annie. All right. Yeah.
I like the fact that he was honest and about that there was no boundaries, that he took advantage of that, so it shows accountability that he really.
Yes, explaining that he took advantage of it, that there was no boundaries, definitely demonstrates accountability, that he understands sort of what led him to down a certain path. So thank you for that. Accountability is so huge. All right, we're gonna move on.
Yeah.
Oh.
Do.
Oh, yeah, go ahead.
So when you had said that it was, that she didn't care, only thing that I would add to that is that I felt or I thought or I believed that he did not care about what I was doing.
Why is that important?
Why is it important?
Yeah.
Because it takes the blame off of her, the responsibility on him.
Okay, that's a really good point. So it could sound like blaming if someone says like, sort of, this is how it happened, but to say like, this is how I interpreted it, it makes it sort of centered on you and your experience of it. Cool, thank you for sharing that. Sure.
I think that also kind of goes to speaking to the narrative I created in my head that will eventually lead to the underlying why of why the crime was
It
committed.
is the why.
Yeah. Thank you.
All right, thank you. Moving on.
Mr. Spence, do you have a healthy relationship with your mother today?
Yeah. I believe that we do, but it's very boundary today, and we've been able to speak about those boundaries. I believe that boundaries are a very compassionate thing. They set a limit onto how far the relationship can be pushed, but we're open and honest about our past and what we both felt going through the process of me committing my crime. And so it's been good since I've been home.
So also, the CRA state that you were using drugs at that time, is that correct? What kind of drug were you using and why?
So at the time I was using weed, and I started using meth about 4 months prior to catching my case. I was using drugs because it was what most people did around me, and I enjoyed getting high at that time, Commissioner.
All right, phone a friend time. What kind of feedback do we have? Yes, well,
I've read so many board reports where they say, you do not catch a case, that's not a flu, like they will use like little wordings to be like, you did not catch a cold, you know, it's not a cold that you catch, you know, you committed, it's a wording that, you know.
thank you. So Sol said that catching a case, Charlie said he caught a case, and the language you use is really important. Catch it, it's not like catching a cold or catching a ball. It's like I committed a crime. What does that show? Like, why is that language important, Sol?
Because it shows like accountability, and it shows that you're aware of the decisions that you made.
Yeah, it shows you're aware of the decisions that you made. So important for the board. Language is so important in parole hearing. Thank you for bringing that up. Yeah.
Along the same line. I was using drugs.
Okay. Okay, great point. Just to repeat for the people online, that saying I did drugs because everyone around me was using drugs can sound like it's blaming or not taking personal responsibility or accountability for the decision to use drugs. The commissioners love saying something like, well, there's lots of people that grow up around drugs that don't use drugs. What was it about you that's different that chose to use them regardless? So thank you for that. All right. And yeah.
You could add to that answer, I wanted to fit in my practice, or I wanted to fit in, I was insecure and I felt I didn't fit in, and so I used drugs. So then you're explaining the context, people around you work with you, right? But you're expressing a character flaw or a belief system that you engaged in at the time and explaining how you make the choice to be correct, but it's still accurately reflect your.
Awesome, thank you. The suggestion was to explain that the peer influences, like, wanting to fit in a community of people that were using drugs contributed to the decision to use drugs. And that sort of put some of the onus back on Charlie for a decision that he made and the reasons why he made that decision. Thank you. One more piece of feedback about Charlie's response. Anything else you want to hear in the next go around? Okay, yeah.
Just really quick, why you started using drugs is like the same thing, like underneath anger, what was that was going on that led you to using drugs or feeling like you wasn't loved or that you wasn't important or that, that what was going on at that time? What was your mental frame? Like, what were you thinking? How were you feeling? What was going on around you? What was making like that's where the character defects, internal triggers and all that stuff comes in, because that's what leads you to making those decisions to like get high or fight or trying to fit in and, all that stuff that's on top of what's underneath.
Yes, so important. Just again, to repeat, like, what are the emotions under wanting to use drugs? Sometimes we call this like the why under the why. So it's one thing to say, like, I wanted to use drugs to escape my feelings. But like under the why is like, what were the feelings that you wanted to escape? And that leads to the internal triggers, which we're going to talk about or we sort of talk about in relapse prevention plans, is like the board wants to hear that you understand the emotions that led to using drugs, so that if you feel those same emotions today, tomorrow, in 5 years, that you know when to seek help, you know how to use your coping mechanisms, not to relapse into drug use. Thank you. It sounds like really good advice. All right. Are we ready to hit the play button? Yeah. All right.
Were you using drugs at the time you were committing a crime? What drug? You have okay. What drug were you using and why did you use it?
At the time, I was using weed and meth. I started smoking weed when I was 12 years old, and I started using meth about 4 months before I committed my crime. There's multiple reasons why I was using drugs. Part of the reason is because I normalized drugs at a young age. They were in my environment all the time, and I became to see them as normal. And eventually I adopted them as a dysfunctional way to cope with the feelings of powerlessness and helplessness that I had as a child growing up with the abusive experience with my dad and my stepdad. I realized that I didn't actually help me cope with anything, that I was avoiding dealing with my painful emotions or what I saw as my painful emotions. And it's my responsibility today to be able to deal with those. And the other reason that I was using drugs is because it provided me with a false sense of acceptance from my friends. Growing up, I always felt different than everybody else. And drugs allowed me to escape those emotions and cover them up.
All right. I think you did a great job putting that all together. What do you think? All right. We'll just take a little pause. This is like real stuff. This is really emotional. And this is, yeah, do we have a comment or some affirmation? Because what? Oh. I wish that we could challenge every subjective thing that happened in a parole hearing. If we could do that, I think there would be no parole hearings. And I don't mean to say, like, I think that that's a really good point. I think so much of what these hearings are about are subjective. Their words like healthy, their ideas of like what is a violence risk, like there are things that are like unanswerable and they're not an insight. It's not a dictionary, you know, they've never defined it. And these are the real things that the parole board is making decisions on. As long as the commissioners can articulate, you know, a reason why they think it has some connection, it's relevant to a current risk of dangerousness, I believe that they would let that question continue. Does anyone else have a different perspective on that? Any other attorneys or, yeah?
So I think the question that you asked is that I can still answer that question because I normalized an unhealthy relationship. I understood an unhealthy relationship. And as I'm taking these groups, I'm now learning to understand what a healthy relationship is, and we're working towards that.
Yeah, of course.
I think that through the self-reflection discovery process that those engaging inside prison, there's maybe not a written definition, but an understood definition of what is considered a healthy and an unhealthy relationship. And so although we would not want to go in there to try to redefine what their understanding of the definition is and kind of work within the definition we understand them to have. I think it's just easier. It's the path of least resistance. Because in almost all the groups, we work through the definition that the board understands. And so for me to go in there and maybe try to articulate that I have a different understanding than they have might be seen as confrontational or combative and lack insight into the definition that they have. So it might not be to my advantage to do so.
Thanks, Warren. All right, we got the green light. We're going to keep moving and please hold your questions. We'll come back to them. Thank you.
Mr. Spence, how are you feeling? Nervous? No, just ask for a break at any time you feel like you need one, okay? I know. Okay. How did you met your co-defendant, Mr. Thomas, and what was your relationship like?
So I met Thomas at my house. He came over with some other friends, and in order to get high, I liked him right away. He was funny and cool, and we started hanging out after that day consistently from that point on.
All right. Any feedback? No, wait, see if anyone who hasn't given that any feedback yet wants to jump in. All right, green sweater back there.
Consideration or reflection on how the relationship was likely negative.
Okay, yeah. So it maybe has the same tone as the first response to how was your relationship with your mother. It focuses on some of the positive things he liked. Doesn't really explain how this ended up being his co-defendant. Okay, or the relationship. All right, I think you also have, yeah.
When I was 12, and at that time, I thought it was cool that this and that or whatever, just to kind of differentiate the 12-year-old girl from now, that he probably wouldn't make those things at school and he would go around.
Okay, yeah, that's a really good like tip for parole hearings is like differentiating thought patterns from like when like at the time of the life crime versus the thinking today. Sometimes if you don't differentiate, it can sound like that's still the way you think, and that can be dangerous if you're trying to show transformation in different ways of thinking. Thank you for that feedback. Yeah. Thank you for saying that. Like, it's not specific, it's vague. And I think that you probably, like, something in your stomach sort of was like, there's like something he's not saying. And that is a huge part of parole hearings. And like the commissioners are really relying on their own sense of like, does this make sense? Is there something left out? And they're judge of your credibility. And so to stay vague and non-specific can sometimes trigger that as a potential issue. So thank you for that feedback. All right, let's hit the play button.
Mr. Spence, how did you meet your co-defendant, Mr. Thomas, and what was your relationship like?
So I met Thomas at the age of 16, 4 months before I committed my crime. He came over to my house with some other friends in order to get high, and we connected. And from that point on, we did everything together. We'd go fishing together, we'd go to arcades, we'd go watch movies. And at that time, I really looked up to him. He was 7 years older than me. It kind of reminded me of, like, as I mentioned earlier, like growing up in an abusive family with my dad and my stepdad. Like I always seeking that love for a man, and like reflecting back, that was something that Thomas provided to me, and I really attached to that piece and looked up to him. And looking back today, like I see that our relationship really wasn't that, but the times that we were together was mostly revolved around drug use and getting high, and it just really provided me with a false sense of acceptance and love that I was actually seeking from something out there.
Yeah, that for Charlie. I don't know that you all understand like how incredible these men are. And like they're just not only experts in their own experience of like navigating this extremely difficult process, but they've like chosen to dedicate their professional lives to helping other people do the work to come home and navigate this process. So they're like double, triple experts. And they're just, yeah, like just all stars for spending your Saturday here doing this. All right, cool. Any feedback on listening to Charlie? Yeah.
Is the board talking about things that are not important, like example, your mom?
Yeah, correct.
And they haven't said that they like your dad or your stepfather.
Yeah.
You are dating the narrative there. And he comes to your pain in real time. That's why we took the pot. And so because of that, you're taking control of your story and bringing out the really important parts. And you're doing it really exceptionally well in both of these examples.
Thank you so much for that. Like you don't have a whole lot of control over the questions that are asked. You actually have zero control over the questions that are asked, other than maybe your attorney might pick up on some of those at the end of the hearing. But you found a way to sort of drive the car in the direction that you think is important with information that you know the board needs to find you suitable, to understand your story, to understand how you got here and who you are. So that's so important. And it's really gentle. It's not in a manipulative way or a controlling way. He's answering the question and he's just moving the conversation in a place it needs to go. Thank you for that observation. All right, we're good. All right, moving on.
Mr. Smith, you were a pretty smart kid, correct? Yeah, yeah. You knew the gun was loaded, correct, when you gave it to Mr. Thomas? Okay. So, do you have any thoughts that the gun might go off since it's loaded? And why do you still choose to do so?
Well, Commissioner, the thought never crossed my mind that the gun was go off. I was thinking like the movies. You aim a gun at someone and make them empty their pockets and no one gets hurt. Thomas was going to beat Dominic up, and I didn't want David, excuse me. And I didn't want that to happen.
All right. So Charlie was asked a question like, why do you hand someone a loaded gun? Did you think it was going to go off? And that was his response. Any feedback to Charlie on that one?
think it lacks accountability when it is the actual. So that's where the accountability comes.
Okay, can you repeat that once a little louder?
Lack accountability, because it is actually showing no accountability.
Okay, so yeah, talking about the life crime and being accountable is super important. I'm curious why you think that answer did not show accountability, you or anyone else.
I think because he has to show that he was able to protect against law, but when he has somebody loaded gun, we need to be prepared for it to go off.
Okay, so it's not an accountable answer to say, I didn't know it would go off, because sort of the board definitely adopts this, that like, if you are carrying a gun, if you sort of understand the consequences, that it's like a deadly weapon and that it can be used to kill someone. So saying I never thought about it, even if that's potentially true, is kind of a red flag for the board, especially as like a 15-year-old who maybe doesn't have their whole frontal lobe developed. Thank you for that. Any other thoughts or feedback? I haven't heard from you in the green sweater.
I think it felt a little defensive.
Okay.
And the sort of, and it was a super hard question because it was an aggressive, you're smart. It's a difficult, it felt like a question that was designed to put you on the defense a little bit, and so you're in a tricky situation because you were kind of stuck.
Okay, thank you. So for the people online, yeah, it sounded like a little defensive off the bat, likely in responding to a question meant to put someone on the defense. Why, just like, maybe I'll direct this question to you. Why might the board ask you a question that is designed to make you defensive? Does it happen in real life?
Almost every question is designed to see if they can elicit a response that might be triggering to you, to see how do you handle the situation when being questioned. Because as we all know, whether in prison or out of prison, there's going to be situations that are going to be triggering, whether it's at the grocery store, Costco, or anywhere else. You're going to run into people and have situations where things might happen, and we all have to have the ability to be able to respond versus react, because we've seen from our life crime and our social history prior that our reactions weren't usually, in the best decision. And so having the ability to respond to something, to sit and think about something, you were a smart kid, sitting at this, many people would say, well, hey, I was 15, which is a logical response, but it's not an accountable, insightful response.
All right. Should we give Charlie another go at it? All right, let's hear.
You were a smart kid, right? Correct? You knew the gun was loaded, is that correct? All right, so if you knew this gun was loaded, do you even have any thought that this gun would go off? And also, you knew so, how did you even choose to do it?
It wasn't that the thought that the gun could go off never crossed my mind. The truth of it is I ignored it because it was more important for me in that moment to feel the acceptance of validation from Thomas than it was what could happen to David. I cared more about my own selfish feelings at that time than I did about David's life.
How did you hear feeling that response? That was it? Why?
Because he took the responsibility, but also places his causative factors in there of what he was feeling. And if he did not do this, this is what would kind of happen to him in his belief.
Thank you. Yeah, yeah.
Also, his emotions and words that so you could really feel what he was saying versus the disconnect between the words and the
Okay, so you're talking about like how he's saying it too, like, so the words themselves, but then how he's delivering it. What type of what does that communicate? How he was delivering those words? Credibility, what else? Remorse. Okay. Yeah, those are two huge things you want to be able to communicate. And some people, like, you know, maybe I'll ask you all, like, what advice do you have for someone that might not be in a place for a variety of reasons to be able to communicate, like, the emotionality of remorse in a parole hearing? Because that comes up. What tips would you give to someone?
No. So, yeah, I know that sometimes some people cannot, unable to really express with tears and all this, but the body language says it all, right? Heads down, hands down, pause for a moment. I think these are other characters that the board see and recognize. And also there's individuals that had a lot of tears, but instantly they're back to normal. When a person has this sense of remorse, it's still sick right there. They start shaking, right? These are certain things that the board recognizes. Even individuals don't have to really say or express it, but that is the way of expressing how remorseful they are.
And, you know, having the pleasure of working with Charlie for a while now, he talks about his crime openly and freely to help others understand. And each time he talks about it, this is exactly how it comes up because it's still painful for him. I know when we asked Charlie to play the person sitting in this seat, we understood that one, Charlie could do it, but two, it was going to be heavy on him. And so as we started this off and being appreciative of Charlie sitting in this seat and being vulnerable to relive the worst moment of his life for the benefit of others is truly a blessing in and of itself. And, you know, one of the things he said early on was he drew contrast to being 15 and Thomas being 17 and to seeking acceptance. And so oftentimes in a hearing, you don't want to lose sight that, you know, I'm a 45-year-old sitting in front of you, and I made a decision at 15, a tragic and horrible decision, and I'm no longer that person, you know, and in doing the work prior to, it allows you to take moments, because back in the days, there used to be 4-hour hearings, you know, where you might be able to go on a topic and speak about different things and run back to it later on. Now, under the structured decision-making format, you might have a good hour and a half. And so you need to have the ability to put in some points of reference on the fly and within your story. And it only comes from doing the work, talking about your crime over and over again and preparing for this process. So.
Thank you. Thank you. All right. Post-conviction. Deputy Commissioner Hands, it's all you.
Love this seat. As a deputy commissioner, I will be talking about your post-conviction record and looking at your C-file, Mr. Spence, we see that you had a rule violation for a positive drug test. What happened and why did you do it?
At the time, Commissioner, my grandfather had passed away, and I just wanted to escape my painful emotions and get away from what I was feeling in my thoughts.
All right. Phone a friend. Who's the friend? That corner? Okay, so being more specific, not leaving like the vagueness, like, what do you mean? What's going on? Okay, all right. Okay, yeah, over there. Yeah, and the white shirt. Mhm. Oh, sorry. And on the white shirt. Yeah. Excellent feedback. So they're like, if it's external, if like, I did it because I was, experiencing difficult emotions because my grandfather died, the board might come to their next follow-up might be, well, someone else could pass away, something terrible could happen tomorrow. What has changed? What coping skills have you learned along the way to just not relapse the next time something like that happens? Thank you. All right. Oh, wait, wall. Oh, I'm sorry. Someone over here.
Good.
Okay, thank you. Sorry about that. All right. Oh, wait, what was it? Back row? Yeah.
But then now he has more.
Okay, yeah, that's really good feedback. All right, Black's right here. Excellent. So, you spoke with Keith about identifying like behavior patterns. And so the board saw this behavior pattern. That's why they asked him about it, right? That the drug use was a factor at the time of the commitment offense, and it's still coming up in prison. So what like logic might the board have? Like, why might they be concerned about that pattern? Was it? There's no change. What else?
Lady female back with the glasses on, you have a question?
Okay, so maybe like explaining it more in depth what came up for him, what the relationship was like with the grandfather. That could definitely be a piece. So I think, oh yeah, did you have a response to my question? Exactly. So if drug use was a factor at the time of the commitment offense, it led to the commitment offense. You're using drugs today, you might use drugs tomorrow. That could lead to like the same type of harm that the board's concerned about. They want to see like that tie severed. They want to see that behavior pattern no longer exists to believe that you won't commit harm. We can talk about whether or not that is at all valid, but that is certainly the board's logic. All right, you feel ready to give it another go?
Yeah.
Yeah, this group is good. They're really putting you on the spot.
All right, good morning, Mr. Spence. We see that you had some rule violations for a positive drug test. What happened? What did you do and why'd you do it?
So at the time, Commissioner, my grandfather had passed away. My grandfather was an important figure in my life. I struggled throughout the course of my childhood with my relationship with men, but my grandfather was the one consistent person that was always there. And when he passed away, I felt extreme emotions of powerlessness and helplessness. And I was still rationalizing and justifying my behavior at that time. I was still caught up in my criminal thinking and hadn't committed to fully changing my life at that point or dealing with the issues that were underlying my addiction in the first place. So when I relapsed and I made the choice to use, I really dived into understanding what was underneath of it and really coming up with ways in which I could deal with those emotions when they arise, recognizing them. Like today, I realized that I feel powerlessness and helplessness in my chest and in my gut. They show up in like butterfly ways, where I almost feel trapped. And I can use the 5-35 method, which is like I try to identify 5 things I see in the room, 3 things that I feel in my body, and then 5 things I hear in the room in order to bring myself more present. Then I also use my pastor as an accountability partner who I can reach out to and speak to at any time.
I feel like you addressed everything. What do you think? So?
The only one thing thing is like the beginning where, he saw his grandpa as a father figure, but he didn't go into depth. The whole time, I haven't heard nothing about the dad. How did that affect him since grandpa was the only father figure, and then he could have said something too about, and this is why, because I know that grief is a huge part of me relapsing. I did, this is why I also have a relapse prevention plan, and I've taken groups that help me address the grief and loss and how I see it, how I used to see it then, and how I deal with it today. And I don't know, maybe you can go.
Yeah, thank you for that, right? And through the course of a regular hearing, this stuff would have already been laid out, right? Like you would have had more context to the story I'm now trying to answer your questions with. So, but you're absolutely right. Like that would have, like diving into that piece would definitely add context to what was going on. Thank you so much.
All right, we just have time for one more question. So we're gonna keep. Are you sure? Okay.
All right, Mr. Spence, if I can ask you, what do you think the impact was on David and his family? What would you say to them if they were here right now?
I would tell them that I'm sorry and that I can never understand the impact that I had on them. That I've done a lot with my life. I've taken a lot of groups, and I'm not the same person who committed the crime.
Okay, thanks, Charlie. All right. I'm seeing a shaking head. Why is your head shaking?
I'm sorry. Okay. Right one. What did you say? Something else after that. Right. Well, I can never understand, no empathy at all. There's none. No care or no remorse at all. There's nothing there. And the third part, what was the last part you said?
I think it's something like, I want them to know I'm not that person anymore.
Yeah, you made it all about you. It's not about you, it's about them.
All right. Any other thoughts? Yeah.
There are no words, or I can never describe, or I can't possibly imagine how you feel. Which is true. I mean, you really can't. You've never been there, but you can try, and we can all try. And if we all try to understand the experience of somebody who has a loved one murdered, it's really not hard to give a few concrete examples of how that person might have been affected, even if you're not sure. I mean, we can all imagine. So to use a cliche words to never describe, it's really keeping it on the surface and not even really expressing it if you try to understand. Because if you try, you would understand.
Okay. So maybe some specifics of like, at least, even though you may not know for certain, showing that you've done some thinking, done the reflection into imagining the types of harm that you might have caused and the magnitude of harm you might have caused shows at least something deeper. Is that what I'm hearing? Okay. Any last thoughts? Oh, yes.
You don't have to look at the situation. Know that there's control, and maybe those so that you know what we've done.
Thank you. Thank you. Okay, Liam, last comment. Yeah, that's a really good point. So like being able to empathize with some of the feelings of just losing someone, which we know through his last response that he does. So there's some ability to emotionally connect to some of that pain, even if it's not the same pain. Okay. How are we feeling? All right.
All right, Mr. Spence, you need some time? You need some water? Go ahead. Absolutely. Ready? Mr. Spence, let me ask you, what do you think the impact was on David and his family? What would you say to them if they were here right now?
I don't know the exact impact that it had on David's family. But I know that I heard that after I committed my crime, murdered David, that his brother dropped out of school, became a drug addict, got involved in a criminal lifestyle, and ended up in prison. I heard that David's mom went into depression and became separated from the family. I took David any chance to really live life, experience happiness, experience sadness, the joy of having his own children, the joy of being there for his family. I imagine it completely altered the course of their lives. And I can never take back what I did to them.
Thank you, Charlie. Is there something that would feel good to wrap this up? All right. How did that feel? Yeah. Sincere. Yeah. You can feel that. You can feel that energy. Well, I want to just say thank you. Thank you all for joining us on a Saturday afternoon, giving such amazing feedback. You all have so much wisdom and experience and, or just really good instincts right off the bat. Maybe Keith did a really good job in the warm up. But I know that I learned things from just listening to you give feedback. I'm going to turn it over to these guys to see if you have any reflections on me. Commissioners, hearing Charlie.
Thank you, Steve. So kind. No, these are very difficult times to have these conversations. Not only is it re-traumatizing for Charlie, but for our victims' families as well. Every time we get ready to go to the board, the family gets a notification that we're going to the board. And for those that have been 5, 6, 7 times, every time you think the family is getting some distance from the pain and the hurt and the trauma, the email comes, notice in the mail comes that they're going to need an opposition letter. And it's just re-traumatizing. It just doesn't end. And so when Charlie said, that he doesn't have all the understanding, but he has some, that's all we can hope to wish for in expressing our understanding of remorse. And that understanding of remorse is changing our lives and doing the right thing going forward. And so a lot of respect to the victim's family, my victim, Glenn, and his family, and C's, I'm sure, as well. But these are difficult conversations for me, 32, almost 33 years later. And the pain and the decision that I chose at 20 doesn't go away. It's still present today. And then as Charlie's explaining his, I can feel his breath. I know you might not be able to, but sitting in close proximity of him, I can feel his breath. And that for me brought up some feelings of my own and just feeling a lot of the pain in that moment. And so, thankful for the opportunity.
Thank you, Deputy Commissioner. You did a great job. No, really, thank you very much for the audience. Really gave some good suggestions and advices because we are learning from each other, right? They say we're expert, but really everybody have different stories, But we have one common goal is bringing these individuals home. That's the goal. That's why we're here, right? Emma, thank you very much for, you know, saying really, yeah. Yeah, appreciate your work and putting this mock hearing together for the audience and whoever may view this event. Charlie, we've done this so many times, but the remorse is always there. That deep sense of remorse. No, really, thank you for being, you know, saying like vulnerable, but also courageous as well, right? Because deep down, the commission asked this question for one specific reason. It's one, maybe one of the hardest question, but what they're looking at is the most sincere answer, right? Don't have to be perfect, right? Just the emotion that I felt Charlie was expressing, my body was like feeling it. As a human being, we feel each other. Pain, sorrow, grief, but just put all together, you know, I really appreciate you, you know, for sitting in the hot seat, right? All right, thank you.
I believe that there's lunch in the back. Any notes from my amazing coworkers who put it together on what people should do right now? Just come get lunch. All right. Oh, wait, Brad does this.
On the left, me, on the right, it's Steve, and the little box.
All right, left meat, right vegetarian, little box of salad.
Oh, no. You want to have her tested?
Mic check, 1, 2, mic check. Thank you. Never done that before, that was cool. So thank you, everyone. I hope you all enjoyed your lunch. We have a lot of leftovers, so if you at some point throughout the day get a little hungry, feel free to get seconds. And we also would like to kindly ask that you all place your masks back on and slowly return your presents back to the front. So our next workshop will be on how to support a loved one through the parole process. And I'm going to invite C to come join me.
How was lunch? Yeah? Oh, great. Right. So today, Paul and I will be talking about how we're going to support our loved one, right, through the board process. It is one of the most stressful process, but also there are things that need to be done. And some of these will be pro plans, right, and support letters. These are 2 key documents that the board would love to see, but it's not required. But before I start, I just want to ask, does anybody know what the pro plan is? Pro plan, have you heard of it? Come on here. Yes, all right, can see show of hands? Pro plan, okay. Can you share what is a pro plan real quick, if you don't mind? Right. You make my job easy, thank you. Yeah. Anybody else have any additional thoughts on these pro plans? Oh, a pro plan is like a roadmap that when an individual come home, I'm not word for words here. It's a plan that I think Keith mentioned earlier. They really want to see a concrete, right? A detailed concrete plan. What we're going to do the next a week, a month, 2 years, 5 years, whatever it may be. They want to see it so that we have the thoughts and idea. This is what we're planning to do. But accordingly, the plans don't always go as planned. So we learn how to adjust. Is that right? You have a. Okay, thank you. So.
Take the clicker. Hang on. Yeah.
So for me, right, I love asking questions because it is interactive so that we can learn from each other, right? Please feel free, if you have a question, just raise your hand. Either share your thoughts or your knowledge or your wisdom, because all of us don't know, even I'm included, right? So just like, what I'm saying, a circle of knowledge and community that come together to help each other understand what is a program, what are, say support letters is really key. 1,000, that's correct.
Which button?
Which one? Okay. What is a pro plan? We spoke about earlier. A pro plan is a detailed plan that your loved one will present to the board to show that they reflected on and through about life after they're released from prison. We spoke about, right? It's really, really key that they need for us to understand what are our plans when the individuals come home. Pro plans should be realistic and concrete to show how your loved one plans to re-enter community in a safe and supportive way. If I'm looking at, there's 2 words that really stand out, realistic and concrete. Because I remember when I was in there, I have a lot of like, this is what I want to do when I come home, right? This is what I want to do. But when I come home, realistically, it's not really real. A person like dream, I want, one day I want to play an NBA, 6 months, or be a quarterback for the Niners, right? Take broady job, right? It's not realistic, right? It's not realistic. Something realistic is like, find a job. If it's, we call it ABC, any job, better job, and career, right? That's what, somebody really hit me and said, hey, look, bring back to earth, right? And know that, take small steps because we're building that foundation when we come home. And there's a lot of stress coming home, I'll tell you that right now, right? So they want a realistic, concrete detail of the plans. Okay, what isn't a pro plan? A lot of people or a lot of individuals get mixed up with relapse prevention plan. Two big difference, right? I know individual here have put together a relapse prevention plan. Can someone please share with me what is the difference between relapse prevention plan and pro plan?
The relapse prevention plan is an awareness plan where you basically write down like what are your internal triggers, what is things inside that feelings and stuff like that will trigger you, that you need to be aware of.
Right.
That when a situation comes up, you need to be aware of that so that you don't react in a way where you're going to be violent, where you're going to end up going back to prison.
Right.
Like the external triggers, it's like things around you that trigger you that can cause you to basically like going back to violence or going back to drug use, and things like that. And then like the way that I did mine, I wrote a little bit of talk about like why was this plan important for me and how I deal with it then and who I am now, how I deal with it now.
Right.
And then like the coping skills, like what are the positive things that you can do to help you deal with those triggers, to help you deal, like example, for me a big thing is gardening. Like what is gardening for me? My garden, it brings freedom to me. It makes me process, the things that I'm going through, my feelings, my thoughts, everything. And then like, what else I wrote? I wrote, everybody does it different, but on my end, I did it internal, external triggers, character defects, coping skills, and a hypnosis of who I was then and who I am now, so that whenever I go back to it and I read it and I'm like, okay, this is a reminder of things that I need to be aware of.
Right. Thank you for that, because I know it's just not a relapse prevention, it is the living plan. I'll tell you one thing, I use it every day. Driving, seeing cars cut off, take a deep breath. Don't take it personal, right? They might be rushing, it's like emergency situation, whatever it is. Because that's a big difference. The pro plan is like a plan job, which we will talk more about that in a minute. Okay, pro plan. There's no one right way to create a pro plan. Focus on the content or the formatting. Sometimes we look at the resume, right? It looks different, but the key component in it has to be in there, right? Focus on showing the board that your loved one has the resources and tools available to meet their unique needs. What does that mean? What does that really mean? Yes.
One thing that I to help my clients put in a pro plan like this, if they have a risk factor, they can talk about that, be the subject of a relapse prevention plan. Let's say that they have a substance abuse problem. And they might want to find some resources in the community, like an AA meeting or another substance abuse treatment program that they could include in a pro plan and show the board, I take this problem seriously and I have a plan if I need help. Directly addresses one of my risk factors.
Absolutely. Thank you for sharing that. Yes.
Yeah, I think one thing that really comes to mind in what you just shared, what Sol shared, is specificity and individualized. Being specific, saying, this is the job that I would like to work towards. Inside, I worked in the kitchen, so I want to do some sort of like cooking type of job outside in the community. This is my resume. These are the people who I would like to reach out to for support in the interviewing process. This is my goal timeline for what that will look like. Individualized, Sola said gardening. What are your particular resources for supporting yourself? What are things that you look for supporting your mental health? Like she mentioned about the AA and NA. This is a list of the local AA and NA meetings where I will be paroling to. These are my key 5 people who I can call when I am struggling and I need support, a mentor, a sponsor, etc. So being as specific as possible and making it so unique to you, because like C said, this is a living document that exemplarizes what you specifically need and how you will address the challenges that you're already thinking about ahead of time. So in supporting someone in developing a parole plan or an RPP, it's about asking those questions. What do you anticipate? How can I support in being a resource on the outside that can help you find the information? One of the things that we're so privileged in having as outside supporters is access to the internet. Something as simple as saying, hey, is there anything that I can look online for you that you might find helpful to add into your parole plans? Can I look for local sponsorship opportunities? Can I look for job opportunities? Can I send you a guide on how to apply for employment as a formerly incarcerated person? And in my role as a legal assistant, I often, do those Google searches, send those documents, and that can be so integral to what someone includes in their parole plans and their RPPs.
Everybody has the different needs. Some may have an addiction problem, some may have like criminal problem, whatever it may be. It has to be tailored specifically to the individual needs. Yes. So what you're saying is like it continue to evolve, right? And it's very detailed. One thing that I didn't put in there was the taxes. It's just crazy taxes nowadays, right? So yeah. Okay. So suggest sections and topic to include a timeline of your loved one's needs and goals post-release. This is really, I think it's really important. They break it down bracket. Well, at least for me, right? It's like the first bracket would be first week. What I do in my first week, right? 24 hours, I gotta go check on my parole officer. That's the first automatic. Then I'm gonna check into my transitional housing, right? Then the following, get my IDs, getting all these documents together and everything. These were the needs, right? And I make sure that I did everything in that plan for the first 7 days, because that is very vital, especially the IDs. Some individuals don't have IDs. Even the driver license, you submit a new one or replacement, it's gonna take weeks, probably, more than that. But these were the 7 weeks, first week, the months, 3 to 6 months, a year. It has to be at least details, right? Details, because they want to see that you gave a lot of thoughts about your goals, your plans. And within this, I know one of them was after 2 years or whatever, get off parole. Thank God that I was able, 1 year, and I was discharged, and a lot of my peers was discharged the same too as well. But they want to see that, right? So that's the timeline. The second part is job offers, support letters, research explaining how they will support themselves financially. Really important. The financial part. Have anybody seen the standard of living today? I can't imagine someone just did 10, 20, 30 years, come home, right? I'm trying to survive, right? The job, coming out here, Bay Area, is much easier than other areas, right? So these are like support letters. Before going board, we have to write, potential employers, which you, whatever it may be, right? It's really important. Also, the support letter from family. Like family members knows who, like, example, my brother, he owns a construction company, right? So I say, can you please write me a support for the board that, you'd be able to offer me a job when I come home? And please include, what are the wages and everything. These are really key, real important, because the board wants to know how will you support yourself when you come home, right? Okay, the second one is housing plans and transitional housing acceptance letter. Oh my goodness, this is like dream center, right? LR 360, all these transitional housing, right? Is it okay if you can share that part? How important are those transitional housing acceptance letter? Can you share? Yes.
It's very important to foundation, you have a place to go. Don't just have one acceptance letter or a place to go. Have plans A through Z if possible. I have 3 acceptance letters, and then it's very important. It's like the most.
Right.
Now that there's geo services, is it just as important, or can the plan be utilizing CDCRs?
Right. So, like I think you mentioned earlier, 1, 2, 3. Right. I think which one is right there that we can able to get in, because sometimes the first one don't always there's no availability. So we go down to the second one, down to the third one. So.
One issue that I had when I was in prison and I was getting ready for court, I'm not gonna lie to you, I wrote, every other day, I was putting a stack of mail like this big in the mailbox, reaching out to different programs and different things. And a lot of them go right back. So it's extremely important that you seek support out to reach out to these programs and, for acceptance letters and stuff like that, and what they offer and everything, because sometimes it's very hard for people to get it, you reach out from the inside. And that was my frustration. I was like, oh my God, I'm writing all these letters to all these places and I'm not hearing anything back. So, thankfully, I had Uncommon Law in my attorney and in the Inside Garden program, they were helping me a lot with getting ready for my reentry and all that stuff, that they helped me to reach out to different places for acceptance letters.
Right. Yeah, I remember those days too, those stack of those institution envelopes, usually since certain transition housing would write faster, then majority of the time they don't, right? That's the reason why whatever we can get is great. Just keep.
Make sure you repeat what they say so folks listening on the stream can hear it.
Yeah.
So Sol was speaking to something really important, and she's speaking from her experience of being inside and reaching out to dozens and dozens of transitional housing programs, and at times not hearing back at all. And I think that that's really important to, I guess it really enforces how important it is for outside supporters and loved ones to reach out to their loved ones and say, hey, what can I take off of the table for you? How can I support in this way? We have access to email, we have access to phone. At least when I've reached out to transitional housings, I've dozens of times have just called, emailed, and that removes not only the burden of the difficulty of doing that, but also the financial burden, speaking to getting mail, stamps, that might not always be accessible to folks. And so, yeah, Soltis spoke to that and also really shows and exemplarizes how important it is to begin this process ahead of time, and expecting there to be a sort of long-term dedication, like focus on getting those letters from transitional housing programs, because there aren't enough, and there are people with like special things that they have to consider. In advocating for one of our clients, we discovered that it's really difficult to find transitional housing for disabled people who are elderly, who have special accessibility needs. There's a gap that definitely needs to fill, and we won't always be able to do that, but we can do what we can from the outside to find those resources for our loved ones. Yes.
Also, as an OWA, and when I was reaching out to different programs, they're like, when you have life without parole, how can we accept you into our program? You know, so I have to explain that, and so it's very important.
Absolutely. So she just shared that as an LWOP, you're reaching out to transitional housing programs and they're saying, well, this doesn't really apply to you. That is definitely one way to navigate that, I would imagine, is by saying, well, can you send me a brochure? Can you send me information that I can include in my own parole plans so that the Board of Parole sees, like, I'm anticipating this way ahead of time because these are things that I'm thinking about for my journey home, no matter what that looks like and what that timeline looks like. It's never too early to prepare for those types of things. Yes.
And I also had what I think contributed to that program. I talked about myself, right? I introduced myself to the program. Said, this is who I am, this is what happened, and this is who I am today and what I can contribute to your program.
Right.
And I got accepted.
Right. Yeah.
And then Maslow's hierarchy of needs, like the basics, it shows that,
Mhm.
okay, so that's important.
Absolutely. So reaching out to transitional housing programs and say, this is who I am, this is the crime that I committed, or where my background, what that looks like, and this is who I am today and what type of support I need, and that shows proactivity.
And so also another thing, family members can support by reaching out to these transitional housing. It's a phone call, it's an email, or whatever it may be. That's what we can do, because the access in there is quite difficult. But family member transition out, Dream Center, whatever it is, call them and contact them, and I think that has a personal touch to it. This transition housing letters of like acceptance, 6 months to a year from the pro applicant going to the board. If it's a year older, they may consider it, but they want a more updated one. So that's why it's really crucial, very important that again, these transition housing accept this letter in there. Viable transportation options. I don't know if anybody lucky enough to come home and have a car waiting, right? That's where like also, I think some of it is like resources. I know this Oakland over here in San Francisco have the BART station, bus, whatever it may be, right? And I remember at mine, I even include the route where I'm going to work, right? All that details, it really matters because parole applicant put so much thoughts into it. 8 o'clock, this bus, BART, then right here at 9:30, and boom, I get my work. Those are really important that they need to know how can you get your job, your programs, report to your pro agent, whatever it may be, right? So it's really important. If we can even like print out the schedule and send to our family members or a pro applicant, then that would be even more better. Any questions so far? Any thoughts at all? Yes.
The default in the state of California is the parole to the county of your crime. But you don't control the benefit. And this is how you indicate to the board that you want to go somewhere else. I mean, just gonna parole, my crime happened to school, but I want to move to LA, and I'm looking at this housing in LA. I mean, it's tell the board, here, I want to go to LA. And I want access to the board, when they place you in the community, they'll place you in the county that you chose. Instead of the county that you default to, so it's really important that you develop plans that are really geared towards what they want.
Thank you for that. One other thing that I want to go back to the housing, transition housing, because a lot of individuals come home, they want to spend time with their family. The board would not suggest that because they still want that transition part, right? to have that structure, call it the structure, right? To transition, get that process together, then go home where, the person wanted to go to. But it's also like, that has to be communicated to the pro agent too as well, right? Plans for assessing services and program that is responsive to their needs and history. AA, CGA, right? These mental health, whatever it may be, whatever the specific needs that the individual need, include that part. Because I know that, there's a lot of issue with mental health, right? And I remember I was helping an individual that they were struggling to get these resources, right? So we contacted through writing, can you please give us a list of mental health, right? Because that's the individual specific needs. It's the mental health part. So we were able to put the resources together, right? And somebody who used to have an addiction, like substance abuse, we have a whole list of NAAA throughout the county because that's the need. That's really key and it's really important because everybody needs are different, but they want that to be included in as well. A list of their community support network. I'm just curious, right? It's like community support network. What does that mean? What does that really mean? Does anybody have some thoughts? Who are the support network, right? Who can they go to when they go feel a certain way, right? If they financially, unable to get a job, who can they reach out to? Is it temporary, a job placement? Is it family to borrow the money to get ends meet until get a job? Is it connecting, calling the pro agent? I have a hard time getting a job. Can you please recommend to get a job? These are really, really important because that support network is individuals who the individual can contact if they go through a certain situation. And I know that mental health is such, I can't say enough about this mental health. Because in there, it's like me, it's something people don't want to recognize or be known for. Because I think there's a false sense that there's shame there, right? I think to acknowledge that piece and find the help is really important. If it's called, to even have the treatment as well. So I think mental health, addiction, whatever it is, find that resources or the support network. I call my brother all the time, right? When I'm going through a certain instinct, it's like, man, I feel a certain way. I feel really lonely. Or I feel really hurt. When I think about Andy's family on the day that I committed the crime, it hurts me all down. And because it reminds me that his parents, his family, they're going to think about their son. They're not there. He's not there to enjoy the moment of life, right? And it hurts me, right? And that's why I call my brother and say, hey, Howie, you have a minute? We talk about it. No, he helped out. Hey, sit with it. It's okay to cry. Let it out. I think that's really important, at least for me, right? People who I can trust and go to. Sometimes I'll call Charlie. Charlie, I want to check with you too, right? These are the support network that we need as a source of our life, right? It's really important that we do have this support network in the pro advocate, and you're probably on that list. Immigration codes. This is the second plan. It's the immigration pro plans. I have an ISO. The board asked, not the board, but Lily told me, see, you might want, create another pro plan for your country origin. I'm from Vietnam, right? I'm from Vietnam. I'm up for possibly deportation. So what I did was contact my family, my brother, my family. Is there, anyone or anything over there that can help, that I could put a pro plan together, right? A job. Lucky that somebody over there, a cousin, did offer that, but we have to have, it's really important, just in case, right? We do get deported. They want to know that, they want to see that as well. Be ready to answer question about the stress of deportation and resources. Okay, so what are parole conditions like in country of origin? I'll be honest with you, I really don't know. Right, in Vietnam, I don't know how they're gonna see it, how they're gonna view it and everything, but I know what my part can do is like, I did put, you know what I'm saying, certain programs over there. It's so limited. It's not like here, they have a whole bunch of range, they have so limited resources in my country, right? And it's not easy. Only like for me, family members be able to make that connection. I wasn't able to write to Vietnam. I wasn't able to reach out and get a response. I can imagine by the time I get a response, probably my hearing is over with. So these are things that, you know, so it's like we need to do in advance. We need to do in advance. What types of reentry support people are providing in the country? Again, as far as I know, there might be such a limited support over there with NAA because, be honest, our culture, we like to drink. They drink all day and not realizing they have an issue, and they normalize it. So, you know, they're so limited. But if we can like get resources, include that in there as well. Are there any organized or services that you have connect with a country of origin that would utilize on parole? Again, I'm not sure Vietnam have any organization that does this kind of thing, right? But the key thing is, I think, is more for me with this immigration program, is having that same structure, very similar structure. Put whatever resources or information that we have on this program who has an immigration program. What specific challenge do you anticipate if parole to country of origin? My greatest fear, if I was deported, because you know my family came to this country when I was 5. We fled the country when I was 5 years old. My dad fought for South Vietnam, so they consider him as a traitor. You know, I can't imagine what kind of the fear I had going back to the country that I really don't have no clue. 5 years old, I don't remember much. All I remember was getting on that boat, fleeing the country in the dark boat, come to this country, we have nothing. We didn't even know what our next meal will come from. And it was difficult. We couldn't speak English. In the middle of the night, we just grabbed our stuff and we just left. That's all we had was a pair of clothes that we have on us. And it was a huge struggle. But saying that right there is like, I don't know how the Communist Party would treat me if I come home. But there will be a danger risk because of my criminal conviction, because of the crime that I committed. Those are my fear. Begin to brainstorm by thinking about continuing community skills. Do you have any family who can be part of our support network in your country of origin? Well, earlier, I have a cousin. You know, he also had a business and everything that he offered a job employment acceptance letter. That was so key because the board did ask about that, right? Said, what do you plan to do if you were to deport? I said, yeah, you know, I have a cousin over there. He also have a construction company that I will be working for him and everything. So commissioners kind of just like, okay, good, let's move forward. What are some religious organizing public service or program you would be able to get involved with? It's really basically up to the individual faith, right? In Vietnam, there's like Buddhist, there's like Catholic. Those are two pretty much major religion, right? So it's really up to the pro-applicant. I think to me personally, it's very personal. You say, yeah, I believe in this and this and this is what I'm doing. But, you know, to me, it's good to know too as well that the board need to know, you know, saying, where do I get my spiritual support from, right? I think that's really key, really important as well. What job or language skills do you have that might help you find employment? Again, I came up with 5 years old. You know, I really have this little tic-tac kind of like Vietnamese still that I can still communicate with my mom. But just to have a full-grown conversation with somebody who's originally from Vietnam would be more of a difficult thing. So, I'm grateful for that, just to have some kind of roots and culture and history in me still, where I'll be able to communicate. But just saying that these are the skills I have, I was in building maintenance, these are skills I have. Building houses, concrete, flooring, whatever it may be, these are skills that I can also have to bring back to the country. That's an example of the pro plan. Does that look familiar? That looked like mine actually, but this is supposed to be the bad one, right? Yeah, that's as you can see, really it says what county I'm Burlington. Either it's like San Francisco or Alameda right there, and there it goes. That's long-term, short-term in transportation, and let's see. Yeah, that's right there is the not good pro plan. Let's see, this one right here is a really good pro plan. Can everybody see that? I know, you see it, right? This one is more specific in details. The other one is more vague, but this one is more in details. Well, hopefully you do have copies of this, or okay, cool. Yeah. So, can you see the two differences in pro plan? Which one would you prefer? The first one or the second one? Why so?
Because of addresses and stuff for people to reach out to.
Right.
And you have coping skills and steps and, and then additional family contact.
Right. So this is more specific details and personalized. This is what this pro plan looks like. Right. Any question before we go to the support letters? Any thoughts? Yes.
Educational plans, absolutely. Do they take the
Absolutely. That's what they want. Your question was like, can you add educational plan in your pro plan? Is that correct? Yeah. So I think if anybody do that, do it. I would support that because higher education, right, is very productive, right, and it's just a path of a right path. Okay. Yes.
On my production plan, I added places that, my first week of what I wanted to do and specific with addresses and stuff. And then I talked about my restitution because I still owe restitution and my goal of when I wanted to finish it up or make or get into a payment plan. And then signing up for college, looking for, going to AA meetings, getting a sponsor or getting involved with different organizations that have volunteer services or different programs. You could go and, and they liked it, I went in detail, different things.
Right.
And I have all this information, websites and address, phone numbers, everything.
That's one of the reasons why you're home, right? Yeah, but I would encourage the pro plan within 1 or 2 pages. If it's more than that, then the commission's gonna just go through it. That's it. But yeah, that's what pro plan is, and I'm gonna send the mic and over to Pam.
Thank you, C. So now we're going to talk about letters of support. So what is a letter of support? The main purpose of a letter of support is to write a letter from a community member or loved one to really show that someone is ready to come home, specify why, and from your personal support, what you can offer. And there are 3 main types of support letters. One is the parole plan, the other is general support, and the third is testimonial. So we will break those down. So a parole plan letter is one that outlines a specific offer of assistance, like residence, employment, transportation, counseling, mentorship, etc. This letter will accompany the parole applicant's parole plans. So oftentimes people will ask us, how much do you think the board cares about my support letter? And I say, well, If you align it really well to what's written in their own plan, they can mark off, okay, in this person's parole plan, they say that they will need a lot of emotional and mental support, mental health support. And then we have this other letter from their therapist or their sponsor who's saying, I am the person who's willing to offer mental, emotional support. This is what that looks like. Now you're aligning two different things that are so structured and specific to that person's plan that it's a really important letter that the board sees as a tangible, concrete system of support that this person has. We also have housing. If you are offering a place to live, you might write, this is the address where this person would live. This is how many rooms I have available in this house. This is what the environment looks like in that household. Very quiet environment, just me and my family member. This home will be available to them for this amount or no amount, being as specific as possible. If you are offering a job or an opportunity for a job, you might say, I am willing to offer them this job, performing this role, and this would be their starting pay. Or you might say, I work in this field, and I can help him get through the door with an interview, or I can even help them by doing a mock interview or offering to tailor their resume and do that type of support. I can drive them to the job application. So these are like really intricate and small and detailed, specific ways that you can outline your support in a support letter. Or you might be offering mentorship or counseling. You might say, I am qualified in offering this type of support. We have a lot of social workers in the room, I believe, or people who have done support for sponsorship for people with AA. And you also don't need to have qualifications to offer someone emotional support. Like C said, the top person on his list is his brother. And that's so important to have that deep, vulnerable connection with that person and saying, I can offer that. This is how I can offer that. As well as AA and NA, which we kind of spoke to in the parole plans. As supporters on the outside, we have the ability to research, find lists of places. And I also, in the theme of specificity and individualizing these plans, I think about Native American folks who, instead of following the normal like AA and NA, they might do the red road to sobriety, and they might be involved in sweat lodges. Or there might be folks who take other religious routes, and that also supports them in their sobriety. So being as specific as possible and making sure that it's individualized to the person is really important. If you're able to offer financial support, you might say, I will send them a bag of clothes upon their release so that they have like a set of clothes upon release. I commit to sending them $100 a month for a year. So being as specific as possible. And then there are general support letters. If you're a longtime friend, you will want to explain how you know the parole candidate and explain how exactly you will offer them emotional support once they're ready to re-enter into the community. For example, you might say that you'll drive them to family gatherings, attend church together weekly, or drive them to AA meetings. If you've not known them for a very long time, you might say how you know this individual if you recently met them. And you can even offer to be something like a 12-step sponsor. There's people who like meet volunteers from inside, and they might say, I met this person in this specific group. This is why I support them being released. What to include in a letter of support. The board's address in a formal salutation saying, Dear Commissioners, or this letter is to the Board of Parole Hearings. State who you are. My name is Pau Cortez, and I am a longtime friend and supporter of this person. If you've stayed in contact over the years, you might say that. You might briefly explain your knowledge of who this person is and how they've positively changed over time. And there's also the section of what not to include in these statements. So any suggestion that the crime was not serious or was a mistake, definitely not the place to say something like, they didn't mean to do this, or this was a terrible mistake. This was just any sort of like minimizing statements that you might be like inserting on their behalf, which is definitely not be helpful. Any statement suggesting that your loved one has behaved perfectly, especially if they have not. There might be varying levels of knowledge that supporters on the outside have about someone's like 115 history or rule violation history inside. Definitely not a place to sort of speak to like them just being like this perfect person, because it just wouldn't be helpful. Statements suggesting or directing the board on how to do their job. You have to do your job right. This is the right choice. The board would not take kindly to statements like that. Where to send your letter. You can send the letter directly to the board. You can send the letter to your loved one, or you can send it to their attorney if they have one. Well, they will have one, stay appointed. When to send your letter. 6 months to 1 year prior to their hearing, and all letters should be updated in advance of each hearing to show the board that the support offers and still stands. Examples of a helpful support letter. I have known my loved one since 2014 when we met. During the time that we have known each other, I have observed blank. Our relationship has impacted me by helping me to blank. I am prepared to offer my community member employment as starting at a rate of his or her or their employment will be full-time and they will be receiving on-the-job training. Less helpful statements include, you must grant my loved one parole because they have already served more than enough time for this mistake they made, and he doesn't deserve how he's been treated while incarcerated. My loved one has a perfect record while they've been incarcerated, when you know they have a recent 115. And generally, knowing or not knowing, it's just best to keep that detail out. And now the resources that Uncommon Law offers. We have resources in the tables in the back, which we've shared with all of y'all, but we also have resources on our website that expand more on other resources that we have, depending on the type of needs someone might have. So we have how to write a parole plan, how to write a parole plan if you have an ICE hold, parole plans worksheets, how to write a relapse prevention plan, a relapse prevention plan worksheet, how to write a letter of support, a list of California's transitional housing list, which Kiera has done such an amazing job to advocate for and plug, and much, much more. Yeah, I guess I'm just as I'm thinking about all of this, I'm reflecting on the importance of resources and educating ourselves as best as possible and bridging the gaps in that information for folks inside. Oftentimes folks will reach out and say wow, I didn't know this resource exists, and they'll just fly with it. So thank you all for being here with such curiosity and attention to learn how to support a loved one inside, because everyone deserves support from the outside, and we're here to bridge that gap when that's not especially possible. Does anyone have any questions so far? Okay, so C will be joining us again for talking about the emotional impact of a hearing process.
This part right here, I think we spoke a lot about earlier. So if it's okay because of the time, we want to kind of speed up a little bit. Okay, after the hearing, the granting, right? This is key. Really important that when a person files for parole, grant, they come back, great, but also have to understand there's a process of the review too as well. A grant is no guarantee of a grant of coming home, right? So this is the grant right here. We're talking about offer support encouragement during board governor review period. Stressful. I was there. Very stressful, down to 100 whatever day. Is it gonna happen? Is it not? Thank God, Governor signed off. Help locate and research how to obtain driver license, passport, military identification. We have better access to that because sometimes it's been years. All these important documents are lost or lost, period. So we're unable to do it. The family member could really contact social service, administration, whatever it may be, get these documents for the pro applicant to come home. I know I was lucky enough, my brother, he had my driver's license, so I was able to renew. So those are like the key thing, these documents. Sitting close for morning of release, oh my goodness. R&R, sitting close, right? Family can't do that, right? Contact R&R, information, need to send it, I think, 60 days or something that for before individual potential parole. It means a lot when we come home looking kind of like, I don't have to wear those blues anymore. Now I make us look a little better too, so it helps. Support your loved one as transition into the community. That's the thing. We're grateful for some of us who have family, take us to places, support us in any way they possibly can, right? Because coming home, I need my family to be there. After like almost 25 years, my family is really important to me. The big factor that I came home is my family. So it's really important to have this connection for family. Okay, how do you want to talk about denial? This is a tough part.
Yeah, being denied parole, I imagine, is a very stressful situation and experience for the person who has been denied and also their family members. There may be feelings of shame for not being granted parole, people feeling as though they've failed their loved ones. And those are really difficult conversations to have with a family member. And so reassurance, care. Earlier, I was having a conversation with someone here and we were talking about, how to show up for a loved one and just reaffirm constantly, like, I'm here, I'm staying with you on this journey and we're gonna wait and see it out until you come home. And so offering empathy and support as they work through any feelings of anger, frustration, shame, and disappointment. Sending letters or cards to encourage your loved one, visiting your loved one if possible, and not giving up hope. And when your loved one is ready, make plans for moving forward. Checking in and saying, hey, it's really difficult. Let's engage in that collective grief together. Let's not rush through that or see the light right now. Like let's sit in what you're sitting with and what you're experiencing. And then checking in and saying, hey, are you ready to move forward? How can I help with that? What does that look like for you? Questions?
Either we did a great job or.
Thank you all. Yeah, I just really want to affirm that, I wanted to make sure that this presentation was as accessible as possible because we all deserve the resources to bring our loved ones, and it should be things that we can all access and understand and learn. And so I'm open to any questions or conversations. And at Uncommon Law, we have folks who answer the phone and answer questions about what our materials look like, and we're constantly working to make those resources even better. We have some Spanish resources, which I'm really excited about. And yeah, just widening that scope of resources and knowledge that we can offer to folks inside is very important to everyone at Uncommon Law. Aside from the legal representation that we just wish everyone could have. Yeah, and I saw a question. Yes.
Communicate with people who are inside, because about relies on communication, collaboration. I know they have like iPads, the texting, and things have changed a little bit, so if you have any kind of guidance on how to stay with different people, how to follow you.
So you're asking about like how to stay in touch, how to open those lines of communications as a supporter on the outside with a loved one inside. Yeah, there are definitely many barriers to communication. One thing that I was thinking about earlier that I had not really considered in the past was the cost of stamps, like how much of a burden that might be to someone who, we look at the commissary prices and there's many efforts in policy to like make that better. But like we think about people who are like working inside, using the very little resources that they have to get their basic needs met. And then there's this one letter that they want to get out and that is costing them this certain price. I imagine like a world where everyone has like free mail, and I know that like communication is like opening wider with like the rollout of like tablets across California. I heard so many experiences of people saying like, I'm getting pictures for my family inside, like we did video visits, like, yeah, so there's definitely a lot of like opportunity for that to expand even more, and like phone calls like being available for free now. Yeah, I think like, I guess I could speak like personal experience, like me not waiting to be the person, like not waiting to be, like waiting on them to reach out to me. And like my personal experience of having a loved one inside, I imagine it being very difficult. And, you know, I'd always get like this letter on a one-off and say like, I know you're really busy, don't want to take up too much time, I'll keep this letter short. And being the person who's like, hey, like, let me get on your phone list and like, let's talk. And how can I check in? Like, I was thinking about you today. So making sure that that effort comes from us. Those are ways that I imagine just like really opening that bridge of communication, because like the very existence of incarceration makes it difficult to stay connected with outside loved ones. And that's why there's so many people who feel so isolated and alone. And so it's on us to like really push for that as much as we can. I hope that answers your question. Yeah, thank you. Yeah, absolutely. And I think, so, you know, as an organization, like we have different levels of access to like visiting our clients, because like we do it through like the legal visiting office. And so visiting someone as like a loved one, that they're like are completely different steps and processes, which I don't have like full details in terms of like which institution and how, but in my personal experience, like getting on someone's like JPay, getting on someone's like visiting list, like that is a process. Having them send that letter to you to then fill out and then submit. Yeah. Yes.
If you approach a community service provider program, and they have if you approach a community service 4 letters,
Mhm.
does the history of that program and involvement with formerly incarcerated people carry weight with people? Or does that have to be any letters?
Do you mean like a transitional housing?
Sort of. I'm talking about the program.
Oh yeah, yeah. We actually get support letters from Project Rebound. Yeah. There's so many different organizations can say like, this person reached out to us and asked about what our organization can provide, what type of support, and this is us outlining that we would like love to have them participate in that organization. I think that definitely holds weight, and it also speaks to the applicant, the parole applicant themselves, proactively seeking out those organizations and adding them to those parole plans. I think we are all out of questions, but I will be in the back and I would love to take your answer after. Yeah, thank you.
I think we got a break for 15 minutes. Find out
That'd be great. Take it from you. Oh, wow. So we're just getting- All right. So we have all the people that want to be at working with your parole attorney session. All right, why not? Everyone's got one, parole attorney. Why not think about how to work with them?
Am I really? Hi. Good afternoon, everybody. Again, my name is Warren. I'm a parole success advocate with Uncommon Law, working in the Home After Harm program. Today, we're going to talk about working with your parole attorney. And this is a very important thing because I believe, what is the number? What's the percentage? 90% of people go to the parole board with a court-appointed, state-appointed attorney. So there are some things that you can do to help put yourself or your loved one in a better situation to be successful if you prepare throughout the process and become an advocate. Sometimes we believe when we're incarcerated that because there's an attorney in the room or somebody of perceived power, that we might mute ourselves a little bit. And so having the ability to understand what you need to do to be successful on your own is an important factor. You need to be able to advocate on your own behalf. But part of having the ability to advocate on your own behalf is taking the necessary steps to be prepared going in. And there's a lot of things that you can do for that. And we're going to discuss some of them things this afternoon. What do I know about appointed attorneys? Good question. My 3 hearings, I had a board appointed attorney for all of them. The first experience probably was the worst experience. He was new. He didn't have a lot of familiarity with the law surrounding the parole board process. I believe that even because I was still somewhat not following all the rules, so to speak. I don't need that. But I felt during that time of the process that I had probably more information than him. And that was very unsettling for me going into a hearing. The second hearing that I had an attorney, she really knew her stuff. She was well known throughout the board process of attorneys who were state appointed, and she was also representing people privately. I felt that there was a good exchange of information. Of all the attorneys I had, I believe she might have been the most prepared until it came to the time of the hearing. And while I was getting my head roundhouse still, I looked over and she was playing Candy Crush on her computer. Not a very good feeling when you're fighting for your life. And very disheartening, to say the least. and to keep a straight face and to look over and see it and then look back at the commissioners and just know it's not going to be your day. Everything I thought I really believed that I was going to be found suitable at that hearing. And then to look over and see that, I just completely took the wind out of my sail. And for the third hearing, there was actually, the law had changed to where now you were entitled to 3 interviews. And let me back up for a little bit, because even for the first 2, as they're supposed to be there for a certain amount of time, I never got that allocated amount of time. They were in, they were out, they were checking boxes. They really didn't want to look at too much of the paperwork that I had with me. They're, oh, we'll look at it in the C file. And so when both of them came to see me, they haven't even reviewed my C file prior to the hearing, prior to the meeting. And so how good is the meeting actually in furtherance of me going to the hearing if you haven't even reviewed my file? That happened as well. So the third attorney that I had, although he didn't review my C file either, I had written him a letter when I found out he was appointed to me, outlining who I was, what I had done, and where I was at in the process. And I thought I was in trouble because the first time I met him, I said, "Did you get the letter I sent to you 40 days ago?" He said, "I think my assistant got it, but I haven't read it yet." So that didn't start us off on the most positive of footing. But being an advocate for myself at this stage and understanding the process intimately as I did, I was able to let him know about how I felt about that, about his preparedness coming into it, not to be confrontational or disrespectful, just that going into the hearing, there's some things that I expect you to do. I know this hearing is about me, but there's some things that I need you to be able to do in preparation of this hearing. And he kind of understood, and we kind of course corrected from then on out. And he gave me some really good advice about hearings and different commissioners on our second interview that really came into fruition and played a pivotal role in my being found suitable at the day of my hearing. And so I was incredibly appreciative for the information that he did provide me with. But at the end of the day, if we can support our loved ones with the information that we have here prior to going to the hearing, it can greatly tip the scale in your loved one's favor going into it.
Cool. Thanks, Lauren. So again, my name is Emma. I met most of you up on stage a little while ago. But I just wanted to explain like my connection to attorneys, parole attorneys. I am one. So I am an attorney. I represent clients like in full scope representation. So in common law, that means working with people, meeting with them monthly, doing like a variety of things, helping their loved ones connect to them through the support letters and the parole plans, helping people with relapse prevention plans, sort of like more full scope representation, and then being in the room with them at their hearing. The other thing that I do is I do like individual consultation for our Home After Harm program. So that's a much more limited scope representation. And I just have like one meaty legal visit with a person while they're in a program led by Warren and Charlie. And in that like 1.5 hour meeting, I'm trying to give them as much as possible. And through that, I've learned a lot about like what has been super effective that I've seen people do in those meetings that help me give them the best possible advice. So that's my connection. The other connection I have to this topic is that I worked on a lawsuit, a habeas petition that Uncommon Law Keith filed in the Court of Appeal called In Re Pool. That's actually challenging the system that the board has for appointing attorneys. We're going to talk a little bit about that. So I know a lot about, way more than any of you probably want to know about the board system for appointing attorneys. So we're going to talk a little about that, but just wanted to let you know sort of where Warren and I are coming from on this topic. Here's what we're going to do today. We are going to talk about like the legal right to an attorney in parole hearings. It's actually pretty rare a rare like protection. Not very many states have any right to even an attorney like present in a parole hearing. And California actually has a right to representation for people that can't afford their own attorneys. So we'll talk a little bit about that. We'll talk about the expectations of board-appointed attorneys because those are written down. This presentation mostly is going to talk about working with like a board-appointed attorney because 90% of people going to the parole board are represented by them. Also, the expectations are written down in a document that we can access. And so for people that like hire their own attorney, that's an agreement between you and your loved one and an attorney. And so we just don't know what's being agreed on or what the expectations are. So that's sort of like why we're focused on like mostly working with appointed attorneys, but we hope that this is applicable to anyone working with any attorney. This is, again, I'm not an appointed attorney. As Keith said, they didn't take me. No, I'm just kidding. I never applied. But this would like, you know, I hope that people that are represented by Uncommon Law like also have these tips because it makes it a lot easier for us to give the best advice. All right. So like I mentioned, California has a right for parole attorneys to actually be in the room at the hearing. I'm curious, anyone here have a parole hearing and have an attorney and want to talk about their experience being represented by an attorney in a parole hearing? No? Michelle? You want to You will? Okay.
Hi, my name is Michelle. So my first board hearing, I had a state appointed attorney. And much like Warren, at one point when I was in front of Commissioner Chappelle and he was asking me some very poignant, piercing questions, I looked over and I saw that my board appointed attorney was doing a crossword puzzle. And I had to keep my face like, okay, so I'm on my own. I was denied. Who knows if that could have been a pivotal point. But the feeling of helplessness, frustration, being lost and out of my element in that moment was exceptionally overwhelming. So yeah, there's a lot of important information you shared on this.
Thank you for sharing and sorry for your experience. That it's not okay. So that's like the reality. Like what you've heard from Warren and Michelle, like that is what we are seeing on a very wide scale basis with the state of appointed attorneys. We're seeing like we, in the course of our litigation, we sent out a survey to hundreds of people who have been to the parole board. And we know that like the system is failing people appearing before the parole board. We know that people are not getting the support they need in preparing to go to the hearing. In the hearing itself, people are not being advocated for like we think is necessary in order to ensure a fair process. We know at the same time, we know that there's all these systemic flaws. We also know that people like Warren, like so many other people, regardless of who is representing them in a hearing, can succeed in the parole process. And so it's like it's like a both and. Like we want to improve the system. We want everyone to have a fair shot at parole. And we know that regardless, even our clients, people that have a lot of legal representation, a lot of them could succeed without us as well. And so it's we're working on sort of both ends through programming, through home after harm, and then also through the pool litigation to bring more people home effectively. All right. Well, so the board has undergone, I think, with some pressure of litigation, and through like lots of years of like, I think knowing that there's a lot of issues with the system, the board has changed their what it's called a panel attorney guide that outlines the expectations that the board has for appointed attorneys. So I guess like my first question to you is like, is that something that seems right that the board is appointing attorneys that are supposed to be appearing before the board? Does that feel right to people? Why not?
Because they're their own.
Because they're their own.
Yeah, they're their own people. Those are their people they appoint.
Okay, so they're appointing, so why is that a problem? Like your people appearing before you in a hearing? It's not impartial.
Yeah, it implies bias.
It implies bias. Okay. What might be some of your fears if you have like an attorney that's appointed by the people that they're there before? What might you be concerned about? Okay, so the attorney themselves might be worried that they lose their job. Why might they lose their job? Okay, so they like advocate for the person they're representing, like tough, zealously, like lawyers have a duty to do, that they might be punished, they might be fired. What else might concerns me?
If they don't advocate, keep their job, maybe benefit.
Okay. Yeah, so like you might be causing a lot of extra work by advocating for your client, and like you actually want to make the process a little easier for your employer. So you might like not be objecting to certain things. You might be wanting the hearings to move smoothly so that you're preserving the time and resources of the board itself. Yeah. Any other thoughts about that, Warren? Any other thoughts about that? Pretty accurate. All right. Well, so I just wanted to like get that out there as like that's actually one of our main claims in the pool petition. We have a fact sheet back there at the back of the room. Maybe about you can just like wave where the resources are. Just say hi. There you go. That's where the resources are. Back there, there's a fact sheet about In re Pool. There's also a few copies of the panel attorney guide itself. If anyone's like really interested in what panel attorneys are supposed to do, it has all the information. I'm just going to quickly run through what is currently in this document, the most important parts. So right now at this state, in this like month, this panel guide has changed maybe like 3 or 4 times in the past year. But right now, panel attorneys are supposed to meet with each client 3 times. The first visit is supposed to be 3 or 4 months before the hearing. It's supposed to be 1 to 2 hours long. The attorney should have reviewed the client's C file, their prison file that has all the information about commitment offense, disciplinary, classification documents, programming history, all of that. And if the person has an upcoming comprehensive risk assessment, the attorney should explain why it's important, how to prepare for it. I don't know anyone that's been represented by an attorney with these exact requirements, but I am doubtful that some of this is happening, but we'll wait and see, I guess. Panel attorneys are also supposed to meet with their client a second time about 60 days before the client's hearing, or 2 weeks after the comprehensive risk assessment is like submitted and given to their client. And this visit should be 1 to 2 hours long. And the third visit should be before the hearing date, so that's clear in the panel guide. It's not supposed to be like on the hearing date. And the length and timing of the meeting itself is in the attorney's discretion. And something really important that I think also is like a big area that can be complicated for attorneys to navigate, but also is a legal duty and an expectation in the guide, is that attorneys are supposed to make sure that they have effective communication with their client. They should have to understand their client and be understood by their client. So they should use a foreign language interpreter or a sign language interpreter if it's necessary. And that's something that the board should be providing as well. All right. At the hearing, the attorney should be with the client like the day of before the hearing. There's supposed to be confidential space set aside for attorneys to meet with the client. Make sure that you're on the same page. Check in about last minute questions. They also should be physically present. So most hearings today are on video conferencing. And a lot of attorneys we're seeing are still appearing by video conference and are not showing up to the prison to be on like next to their client physically. According to the guide, that should not be the case unless the client intelligently and voluntarily waives the physical appearance of the attorney. So if you have a loved one, that's something that you can talk to them about and explain that like the attorney, the expectation is that they are there in person during the hearing, unless your loved one says otherwise. Like it says, some people are not allowed to waive the physical presence of the attorney, like under these expectations, because they want to make sure that there's like effective communication. And attorneys are paid a flat rate of $945 for cases after July of this year. Does that feel like, I don't know how much you know about attorney pay, but what does that feel like to you? Not enough. I'm seeing like a thumbs down. What do you think, like, so it's a flat rate. So it means like if you spend 1 hour on a case or 100 hours on a case, you're gonna get the same amount of money. What are your reactions to that? Less is more, okay. Yeah, it incentivizes like a certain amount of like economy in your hours. I know, yeah, Michelle. Okay, they might dial it in. Why give extra effort? Something notable too that I just like want to point out that affects me personally as a parole attorney is that there's no like transportation reimbursement. So a lot of these prisons are like really far away. I'm driving 2.5 hours to visit clients regularly. So if I wasn't reimbursed for travel, it might make it less likely that I might come to a visit in person. Yeah. Yes, I believe they do. Yeah. Yep. So just want to like highlight these again are things that we're raising in our law in the habeas petition in Ray Pool, but are like pretty intuitive. Like I think most people, aside from like legal arguments, these are just like very relatable, easy to access sort of issues with the system. All right. Oh yeah, please.
On that last one, where it spoke about signing the waiver to have them not physically in their presence. I remember mine telling me, I could be more vigorous if I was at home. And at the time, you're going to say whatever you want if that's what placates him. If you think that's going to make him, advocate on your behalf, you're not going to piss him off the day before the hearing. So yeah, man, if it's easier for you to be in your bedroom, man, so be it. I don't know anybody who didn't sign off on that waiver, so that's something else to think about. Making the most of these 3 legal visits.
Yeah, so they still have it where that attorney is assigned for the whole week of hearing?
Yes, typically.
They're basically trying to get everyone for the whole week to sign off.
Yes, and in some cases, if you've had a little bit of shaky programming in between, they'll really advocate for you to waive or stipulate.
It is very common that the assigned attorneys do not show up for parole hearings. I was at Calipatria last month, and the officers were shocked that I was there because they don't see people in person come to those parole hearings. They're like, "What are you doing here? This doesn't happen." They go weeks without the attorneys showing up for hearings. It's very common.
And hearings and like legal visits in general, the panel guide says like the attorney should make every effort to be in person for legal visits. And I know I go to Salinas Valley frequently and see a lot of people there. And the BPH correctional officer always is like, I can bring you more people if you want to shave down your time and do them back to back to back to back. I'm like, no, just like 3 visits is good. It's good for me. I want them to be an hour and a half. Like, and it's like oftentimes even like we're sort of like rushed through or sort of like, oh, you're a BPH attorney, therefore you want to like see your clients fast. You want to see them back to back, and you want to be in and out as fast as possible. So that's just like a personal observation that I also see. Cool.
And I know it said 1 to 2 hours per meeting. I probably didn't have 2 hours in all 3 meetings combined. Well, I got laughed when I saw that slide come up. Next, we're gonna talk about making the most of the legal visits, offering some tips and tricks and ways to better prepare for the legal visits. Prepare and bring questions, a huge one, and being able to advocate on your own behalf. One of the best ways to take advantage of these legal visits is by coming prepared and bringing any questions you might have about the parole process to your attorney. Here are some of them. How and when should I submit my documents and letters of support to the board before my hearing? Most institutions have what they call a life index in records. Some guys don't even know it exists. Last night at group, we found out they never even heard of it. The life index is usually, if you could take it upon yourself somehow to make copies. You know, some guys have hooked up in the law library. Some guys send stuff home and have their families make copies and send them back in. Instead of waiting on your counselor to put these documents in your C file, which counselors is not used in the term of counseling. They're more case managers, and they have a lot of people on their list, and they might not really help you too much. So a lot of this you can do on your own if you take the initiative. What is a comprehensive risk assessment and how do I prepare? Asking the attorney to outline what it's going to look like, because oftentimes this is the hearing before the hearing. The comprehensive risk assessment kind of sets in motion what's going to happen at the hearing. If there's areas of concern and that are not addressed in the comprehensive risk assessment, it's going to be outlined, and it's going to be a determining factor what your assessment is going to be labeled: low, high, moderate, high, or whatever it may be. So the preparation for the risk assessment should be similar to that of going to the parole board itself. What are my biggest areas of concern for the board? This is why it is important for the attorney to look at your file before their initial visit with you. Because for us to have a conversation about what my areas of concern might be, you'll have no idea. And usually that we call the first meeting with the attorney a throwaway. You know, it's just basically a meet and greet because there's no substantive information that's going to come out of it because the attorney hasn't looked at your C file. So there's no way to really have a conversation about what my areas of concern are. And you asking me my areas of concern, 9 times out of 10, I'm going to minimize what they are to begin with. And so oftentimes that conversation doesn't even take place until they look at a comprehensive risk assessment. So you're behind the 8 ball in that. Should I bring up that fact that I relapsed 2 years ago, even if there's no record of it? Yeah, I don't know how to answer that one. Okay. Okay. Okay, and you said your name, Daniel. You said you went to the board before?
Yes, 3 times, Mr. Hands.
How would that question apply to you?
Oh, so being transparent, I would acknowledge it and let them know that why I did, the reasons why I did, and then distance myself from that by saying, now I have this in place, and refer back to my relapse prevention plan.
Thank you for that. I appreciate the honesty. Oh, one more hand, excuse me.
Can I defer to the attorney in the room as a social worker, but I read a lot of transcripts and have a different opinion to you about, no, because you came yourself with the truth and they use it against you, and we consider mitigating, they consider aggravating, and so I don't necessarily agree with telling the truth on things. I agree on talking to your attorney about this, but not necessarily talking to the board about this stuff. Good dialogue to have.
Yeah.
I was just gonna second that like these examples of questions are like to bring to an attorney, and that is exactly the advice that I would give. Like just talk to an attorney who can give you, like, who presumably has more context for your whole entire case. You might come out a different way knowing certain facts in the case in certain ways. So hopefully an attorney would be able to give you information about that. So yeah, these are just examples of questions we don't need answers to. These are questions that like could just bring to your attorney to talk about. Michelle, do you have a thought?
Yeah, issue of self-disclosing or self-reporting, it can actually be a really effective strategy to show the board, this is who I am today, that I can speak to, like, you guys didn't catch me at, X, Y, and Z.
Accountable.
And here's what I learned from that. And here's what I do differently. And here's how I incorporated that into my relapse prevention plan. I actually had a moment in my board where they said, what about this 128? I said, okay, like you, because I had more than one. They said, oh, it was in this year. And I said, well, actually, I was actively in my addiction. I can't remember. But if you tell me the person who wrote it, then I might remember what the reference, what it was. And they're like, oh, okay. And they just moved on.
Yeah.
Because it was an honest moment. But I also assess in that moment, I'm going to be truthful because I don't think it's going to be a negative backlash. I'm just going to be honest. I don't remember this right because I was high. Right?
Barbara?
And I told them myself as well. They said, no RVRs. Was there ever anything that you learned that you could have gotten with? Absolutely. And they did.
Yeah.
That was-
And they moved on.
Right.
Here we go. I feel a little different about that, but okay. There was a question on the previous one that spoke about the difference between waiving a hearing and stipulating it to unsuitability. Want to give us that?
Or just something, again, like for a loved one to talk to their attorney about, like, we could definitely go over it. We have some handouts in the back about what the difference is, and Keith gave a good overview, but definitely like just a question to talk to an attorney about, which, like, what do you think I should do? Should definitely talk about the options if they think that they're interested in a waiver or stipulation. What we do know about panel attorneys is that they, because of the flat rate, incentive, panel attorneys might have a more vested interest in someone waiving their hearing so that they don't have an extra hearing that they need to sit through for 2 hours. And so might advise the client to waive or stipulate, like, so they don't do some of the prep work without really like hearing what the client has to say, without really thinking about what's in their client's best interest. And so just like for a loved one to be able to like know that this is a good question to talk to them about, to know the difference themselves, and to really have an honest conversation about whether or not it's in their best interest. Yeah. Oh,
I didn't have that.
oh, nice. Congratulations. That's incredible. There we go. Awesome. What are some other things you can do with your attorney?
These are huge ones for people like me. I have the good fortune of, playing it straight all the way through. So can I practice talking about my latest 115 with you and see if it sounds accountable? That's an incredible, powerful thing to sit in front of an attorney who has the board experience to see what it sounds like. It's another thing to talk around your boys on the yard, or your girls on the yard. Hey, man, what do you think this sounds? Oh, yeah, that sounds great. But they haven't been found suitable. They're walking the yard with you. So sitting with an attorney having this conversation, you might get a more solid answer as it comes to that. And the more you talk about that, which would be an area of concern, like a rule violation, the better it's going to be. The more you talk about it, the better it's going to be, definitely. Can I share these reasons why I committed my crime? Question? Anybody? So.
No, I was just looking at the questions that, right there, and I remember when I was looking at my me and her, it was so good because it was like, kind of like a conversation, and it didn't feel like it was staged or like, because like, when, like for me, I don't like feeling like I'm talking, feeling like I'm like a stage. I wanted to come from my heart. So that's the good thing that I felt like to my attorney. Like she made me feel so comfortable and asked me questions and going in depth and like when I was sharing something, she's like, okay, so let's stop right there. What like how do you feel about this, or what did you or like can you go more in depth about this? And that's what helped me connect a lot of things and go more in depth. Of us, as far as like, my crime, my 128 that I had, like, and different things, like connecting my God and everything. And I feel like it was more like it gave like really good flow. And when the hearing came, I felt more. I was nervous. I was really nervous, but at the same time, I felt a little bit more comfortable because I felt like I could express it.
Absolutely. And that comfortability also goes into the one before about having a conversation with the attorney about your rule violations. You know, it's a big thing. You can also ask the attorney, can we go over talking about my internal and external triggers for substance abuse, which is huge because if you have any history of substance abuse, there's going to be a conversation at that board about what your internal and external triggers look like. What is your coping skills? You know, what are your plans? If these things come up, these things are always going to come up. Question?
Some cases, you don't have a substance abuse involved in the case at all. You didn't have a scheme for substance abuse at all. But yet the presumption board is that almost every prison has some kind of substance abuse problem. How do you address that without lying? Say, okay, here's my relapse prevention plan. If you don't need a relapse because you don't have a substance abuse problem. If there's any kind of plan to create, maybe a plan of relapse violence or internet to subsidize that, how have you address it that you don't have a substance abuse problem when the board assumes you do?
Absolutely. I know for me, I had a criminality relapse prevention plan. I had a violence relapse prevention plan. I had an anger management relapse prevention plan, and I had a substance abuse relapse prevention plan. And I've never had an issue with any kind of domestic violence whatsoever, but I created a domestic violence relapse prevention plan based on I went to prison at 20 years old. And so I never really had any substantive relationships, and understanding that the two reasons people come back to prison are for domestic violence and substance use disorders. And so having the foresight of what might come before me, I wanted to be able to get out in front of it and have a conversation about it. And when it comes to the substance use or alcohol relapse prevention plan, I think the board kind of assumes everybody at some point used something, you know, and oftentimes in our probation reports that go back to your childhood, you might have answered a question, you know, 22 years ago that said in the 8th grade you smoked weed once. And they're going to ask you to have a relapse prevention plan for weed, you know, based on that answer that you gave them 20 something years ago. And so oftentimes for the guys that don't, or the women that don't use drugs anymore, it's just easier to get out in front of the conversation and say, you know, this is what happens in society. Weed is basically legal from the time I went to prison. What am I going to do if these things arise? Do I have a plan in place that effectively deals with them? And based on the groups and the things that I've learned, I was able to formulate these plans to have a conversation, because triggers are going to be triggers, whatever they're for. And it just gives the board, and it closes the loophole of the things that they can use to deny you. If you've gotten out and you say, I can effectively address these things, in my opinion.
Thank you. All right, we're gonna go over a few more topics, and then we'll hopefully leave a few minutes at the end for questions. Another option is that we hear a lot from people that have appointed attorneys or paid attorneys sometimes, that attorneys like don't want any documents. Like, don't send me your relapse prevention plans. Don't send me your parole plans. Don't send me your letters of remorse. Our suggestion is like, bring them to a meeting. If an attorney's supposed to be there for an hour to 2 hours, you know, maybe that's the time to get them to like look at some of your writings on the spot, ask for feedback on the spot, ask them to underline things, highlight things, tell you like if there's a line that needs to be taken out, put in. So for all of these documents, that's like an option, is to bring them to a meeting rather than send them to the office to get some on-the-spot feedback, especially for things that like might be particularly hard, or you might be getting conflicting information from people inside on. Do I need a relapse prevention plan for substance abuse? I haven't used in 20 years. That's something to like talk to your attorney about. You can say, you know, yeah, I was drunk during my life of crime, but I haven't used since. Do I still need one? Those are great questions to like ask when you're working with an attorney. All right. Another thing that, like, you know, I could probably do better too, like as an attorney, is just like clarify like what exactly is going to happen on hearing day. So here are just like some examples of how your loved one can get on the same page with their attorney about what to expect from their attorney on hearing day. Am I going to see you before the hearing? Am I going to have an opportunity to submit any last minute letters of support that day? Are you good? How can I like respectfully ask the board for a break if I need to use the restroom or if I'm feeling stressed? What kind of signal can I give to you? What are you planning on highlighting in your closing statement? That's something that like, I think is fair game. I would, like, I often share my closing statement with my clients beforehand. Does this sound okay? Is there anything you would add? Because it's a lot easier as an advocate to say things than it is for a parole applicant to say things in a closing. Like Keith mentioned, closing statements for parole applicants, we always recommend are really focused on like the impact of the harm and remorse. And it's not necessarily the place to talk about like the programs and transformation. So getting on the same page with your attorney about like, are you going to mention those? Can be a really powerful conversation to have. You can ask them if they're planning on asking you questions. You could even give them some suggested questions. Oh, if this doesn't come up naturally at the hearing, do you mind asking me this list of questions? I really, really, really want to make sure I talk about this topic. I want to make sure that your attorney might say like no, or just not do it in the moment. But at least you're communicating, like you're being assertive about what you might want them to ask you. And then you can also ask, will the district attorney be present? Your attorney might not know, but something to just ask if they do know. You could ask if they know who the commissioners are going to be. Now that all the hearings are online, attorneys usually know who the commissioners are going to be about a week before the hearing. So that could be like the day of or the last meeting. Your loved one could ask the attorney if they know who the commissioners are. All right. And then after the attorney, after the hearing, you could, so in like your last meeting with the attorney, you could ask some questions about what happens after a parole grant or denial. We know that attorneys like generally see their obligation to clients as ending like when the decision is read at the hearing, like they say goodbye and that's it. Which leaves a lot of like potential legal questions open and like maybe no one to ask them to until the next hearing. So something you can do is get on the same page with your attorney about what happens after a parole grant. What's my review period? Can the governor take my date? Yeah.
When does the commitment end?
Oh, when does the commitment end? Like according to the panel attorney guide? Good question. There is a requirement that attorneys who represent people in hearings, if the case is referred en banc, so to an executive board meeting within the 120 or 150 days, that an attorney represents or either shows up to the en banc to speak on that client's behalf to support their grant of parole, or submits a statement on behalf of the client to support their grant of parole. I don't know if that happens. We don't have any data on that to see if like those statements are actually being submitted. I know just through observing parole hearings on months that I don't generally see appointed attorneys speaking on behalf of their clients.
I was just saying anecdotally, I sat in on Bob.
Oh, you did? Yeah.
There were 26 matters and there were 3 attorneys that showed.
Okay, yeah. So yeah, I observed anecdotally the same thing. So these are just questions again to get on the same page about. You can even ask your attorney, are you planning on coming to a non-banc hearing if my case is referred? I want to take this one.
Some of the things to not expect an attorney to do outside of your visit. Attorneys are not required to write or talk to you or your family members. So try to make the most of your time together in person. Definitely happened in my situation. Never responded to a family member's request, question about where to send letters and different things. Didn't do any of that. And we recommend submitting all your own documents to BPH 30 days before your hearing. Absolutely. Take the power that you have within yourself to do the work for yourself. You can't expect him for $945 to do all the work for you. That's just not plausible in my opinion. And these things you can do. Sacramento has a life index, a PO box. You write them, they'll send you back from the classification unit that they have your documents have been placed into your file. And like I said, every institution has their own LIFO desk. And I used to send one to the LIFO desk in the institution and one to the BPH headquarters in Sacramento. And both of them will be taken care of there as well.
I think we're out of time. So I guess just wanted to open it up to like, if anyone has like one last piece, like suggestion that worked for them with their attorney, any other attorneys in the room that you're like, this really helped me when this client did this, would be love to hear just a closing from you all. We covered it all. Wow, way to go, Warren. Yes. All right, thank you all. I think we're gonna have a 15-minute break. I'm looking at you, Keith. Oh, we're just gonna power through. Okay, that's Keith's decision, everyone. Not mine.
I'm checking in because we can start this last panel early, or we can take 15 minutes and start. Let's take 5, well, we'll cut it down. 5, stretch real quick, then we'll get going.
Michelle. Oh.
You just want to bring. Well, we got 2 hours for this conversation, so I hope everybody. No, we may not, because we've been able to have so many parts of this conversation throughout the day, we might not need a full hour. I think we originally allotted for this panel. I want us to get started. People are starting to get tired. People need to go. I want to make sure we cover this part and give people a chance to hear from folks who've been through this process, what it's like. I know you heard some of that throughout the day already. A couple of things before we jump into that we haven't talked about. You've seen a couple of different slide presentations throughout the day. Those materials are on a drive that's shared. We shared the link with you all. Give me a minute. Just well, we took a couple of different ways. We have put together this drive. We will, if you don't have it yet, you will receive, everyone who's registered for Lifer School will receive a link to a drive that has some of these are sort of put together recently, we'll say, maybe haven't been added to the drive. We share with everyone who's registered. And we also we will send you a post-event survey we would like for you to take the time to complete. But it's also, if you have the agenda, there's a QR code you can scan there to give us some feedback about how Lifer School went for you. Changes you want to see, things you want to add and take away, etc. So encourage you to do that. I think we've directed you to the resources we have there a couple of times. And Bob mentioned it, but I want to make sure you all know most of those things are in Spanish also. Most of them are fairly new, recently updated. And you've got to know the main person responsible for those things getting to your loved ones in the prisons is Kiara Brown right there at that table. Please give her a round of applause. And make sure our stuff gets where it needs to be. Thank you, Kiara. And we've had a lot of people involved in putting this event together. Kind of the quarterback of the crew is Lily Paratori. She couldn't be here ultimately today. She's worked with this whole team of volunteers you've seen from our staff who've been here most of the day. Some have gone, but I really appreciate what they've put into making Lifer School what it's become. We started, as I said, 12 years ago. The reason we started it was because there wasn't anything like it. There was no way for advocates or attorneys to know how to help folks inside. The only training the parole board was providing was compliance with the Americans with Disabilities Act, because it was a court order requiring them to provide that training. There was nothing to provide training on how to actually advocate for people in parole hearings. So we started doing this, and I'm really proud of what it's become. And that's credit to the team to help put this together. So I want to give them a quick round of applause. Now I'm gonna yell at these folks, so I'm gonna take this off so I can. So we wanted a group of people who've been through the process to share some things that maybe haven't come up yet. I have some specific questions, but I also want to make sure you all have a chance to ask any questions that come up. And maybe I'm gonna start with I think I'll start with Warren. Michelle, I asked you a similar question, which is about, obviously you're both here, you've gotten yourself here, all of you are here, but you two in particular, you went to the board more than once. Some of you went a gang. I'm not looking at you, Warren, I'm just saying. And so the question is, what was different between the times you went and you were denied parole and the time that you were granted?
My first hearing was in 2015, I think at my 25th year. The board was still incredibly adversarial. It's not nearly as adversarial as it once was. There was more yelling, screaming, and pointing across the table back in them days. And we're a piece of crap. You don't understand this. You don't understand that. And a lot of people came out of them hearings with some trauma to where they would waive future hearings based on what happened in the earlier days. Like, man, I'm not even subject myself to that anymore. For me, I had the opposite approach. Because I knew that the only way I was going to get out was going through the board, they could have sent me every month because I knew that that was the only way out. And so I took it as my first hearing was more of a reconnaissance trip. I knew that I was going to get laughed for my previous behavior. And so I just went in there and dove on the sword, you know. The second hearing, it was in 20, was a little more conversational. But again, it didn't go my way. I got a 5, went from a 7 to a 5. Then in 22, I got found suitable. By the time I went in 22, it was very streamlined. It was, you know, because I had 2 hearings of talking about the commitment offense, social history, and things like that. There was just bullet points on what did I understand about my social history, my understanding about the crime. They saw the totality of the work that I had done. They saw that I finally was able to sustain some clean time and keep myself out of trouble. And so my last hearing was only like 50 minutes of the actual hearing. Then we went, you know, 20 minutes of deliberation, and they came back with the suitability finding. But it was just more of a conversation. And plus, I had done the work prior, compared to my 2015, where I had done some work, but I was also doing some other stuff. And so I wasn't as committed, and the results showed. They showed up with a 7-year denial and a 5-year denial. And so from the first hearing to the last hearing, a lot of it, what changed was I changed my dedication. I had a friend that went to the law library. He had a sign for years at Tracy that said anything for the gate. You know, and I used to look at the sign every day when I used to go to group and other things. I used to be like, man. And I saw people that I knew that were idiots in the early stages of their incarceration that did all the wrong things, who changed their lives 5, 10 years prior, that started to walk out the door. And so it wasn't as like in 2006, 2007, when Dannenberg and some other guys went, we had all kind of wrestlers that, oh, he's white, he's this, oh, that's why his mom is the attorney, that's why he's out, you know. So I can just use that as a justification to keep engaging in dysfunctional behavior. But when I started to see people that had similar backgrounds of messing up in prison like I did, the realization began to sink in that only I was going to keep me in prison. It was entirely up to me. And that didn't feel too good. I wanted to get me out.
So before we go to Michelle, one thing I want to pick up on. So you said you got a 5-year denial in 2020. 2 years later, you were granted parole. Because as he said, he did the work to get himself back to the board earlier. They said 5, it ultimately brought him back to 2, and he came home. So it can be done if you're doing the work. Michelle, same question to you. What was different from the time you went denied parole and then when you were granted parole?
Well, the first time I went to parole, I had 6 months to prepare because, okay, so in 1991, I was sentenced to 2 consecutive life without the possibility of parole sentences. In 2018, I was granted a very rare governor's commutation, as well, one of my other girls right here, by Governor Jerry Brown. I'll always be a Brown's girl. And so I had a board date, 6 months, you're going before the board. I didn't have the luxury or the mindset of those years and decades in prison that one day I'm gonna go. So I started preparing for 6 months. I had literally taken every class, every group you could think. I was a participant, I facilitated, I did mentoring. Like there wasn't anything I wasn't doing. I just programmed from in the morning till at night. have my board appointed attorney, the one that was doing the crossword puzzle, right? I saw him maybe twice. Get in there, answering questions. It was face to face. And I couldn't carry the ball across the finish line. There were a couple of questions I was not prepared for. And next thing I know, I'm being told 3 years. We'll see you in 3 years. You're denied. Oh. I had accepted as an LWOP that I was going to die in prison and had transformed from that into, then what can I do with my time? I'm not just going to do time. So I had mental fortitude. Being told by two people, basically, you're not good enough, you're not worthy enough, you're not ready, rejected. That took the wind out of my sails. And it took me a couple of months. I allowed myself to mourn. I would go out to my garden, pull my baseball cap down a little lower and cry when I thought no one was looking. And then I got my board report and I said, okay, let me go to those last couple pages. Let me look at everything that they said they were looking for that I didn't give them, where I fell short, what they wanted that I didn't provide. And so got out a piece of paper and I wrote each one of those things down. There's my roadmap. And I realized it was very narrow because I had done so much work, right? So I kicked it into gear, a lot of coffee, I'm a bed and got to it, but I also opened myself up spiritually to, okay, so there's a lesson in this. There's something else God wants me to learn or to grow from or realize through this process. And so I humbled myself and I said, so I'm gonna be open to it. And then this other amazing thing happened and I got selected for this program through Uncommon Law. And I was actually matched with UC Berkeley law students under the direction of Lily Partori. And I had support and I had individuals listening to me and asking me the hard questions and, looking at my comprehensive risk, assessment and saying, here's what they're going to ask you about, and let's work on it. And I had support. And I had support from a law firm that inside, Uncommon Law is the gold standard. When you've got Uncommon Law, I'm going to get free. I have people who care. People who know how to get me there. And that was really the difference. Had I been given another board-appointed attorney, I don't know that I would have been as prepared or capable. But having that additional support and contact, really that made a huge difference because I knew I wasn't doing it by myself.
Thank you both. Something that you both touched on is what you took from your first hearing or second or fourth hearing that you then use going forward. And you both refer to basically the transcript from the hearing. The last few pages of the parole hearing transcript is where the board is saying, not only are we finding you unsuitable for parole, but here are the things we want you to work on going forward. There are a lot of people, I've met a lot of people who never look at their transcript. The shame, the pain, the trauma that happens from reviewing that material, it's painful. People just sometimes don't do it. But if you want to know what the board is looking at, if you want to know where they're starting when they look at you the next time, it's at the transcript. It sounds like both of you could see over time that the scope of things they were concerned about and asking you about was becoming more narrow, helped you focus your efforts as you got to future hearings. The other thing that you said, Michelle, that I just want to touch on briefly with the program. We have a program at Berkeley Law. It's called the Post-Conviction Advocacy Project. And we started doing that about, almost 12 years ago, something like that. At least 10 or 11 years ago. And part of it was because there was not much of a pipeline for people to learn as law students about this area of law. And no way to really become attorneys practicing in this area because there aren't a lot of them who do this work. And this program pairs law students with current folks going through the process, and many of them represent those clients in their hearings. We've got several folks who work at Uncommon Law now who are graduates of that program. Emma, who you've been hearing from today, was a PCAP student. Lily, who directs our whole legal services, was a former PCAP student. We've had, I think altogether, 5 or 6 of our staff attorneys, our former students who work with us. We created a pipeline that didn't exist before. And part of, a lot of it's because folks on the inside, Michelle, Barbara, I think you met, didn't you work with some students too? Sol, did you work with students? You didn't get the chance yet. But because you all trust that we're bringing people in for the right reasons, bringing their heart, bringing their minds open to this process and helping. So I appreciate that. The bringing in C at this point, we didn't talk about C, but you got granted parole at your first hearing. That doesn't happen that often. So C must have been a perfect person, perfect prisoner, right? No 115s, great psych report, all that stuff, programming perfect throughout. That must be why you're granted parole. Is that right, C?
I'll tell you the story. Yeah. In contrary, I have a lot of 115. About 13, a bunch of 128 and confidential. So I have a lot. When I first came to prison, my mindset was, what I learned is go in there, violence will give you reputation, acceptance, and validation. The same mindset. So I said, you know what? 35 years of life, I'm not going home. So I'm going to make my name, a name for myself in prison. And that's what I did. Then moments of change, right? In 2012, I remember it was late at night, maybe about 2 o'clock in the morning. And I was just pacing back and forth. And I remember talking to Lieutenant Kaufman that morning because I had a phone violation. So Lieutenant Kaufman and I remember we sat there and everything, and he said, "What are you doing? Don't you want to go home?" Right? I'm looking at him like, home? I won't go board for another 10 years or so at that time. So he said, you know what? Your record shows different than who you are sitting right here. You got all these write up, but you're so polite with me, so respectful. Then he starts saying, you know what? I fought in the Vietnam War. That's what he told me. And he said, did your dad fight in the Vietnam War? I said, he did. Then he said, how would your dad feel about that? How does your dad fight for a country, come over here and struggle that way? Then you come in prison and even destroy the community that you were in, and you destroy here at Folsom State Prison. And it hit me like a punch in the guts. It hurts, but I needed that to hear that from Lieutenant Kaufman. I was filled with shame, guilt. It was the breaking point. So that night I went back around 2 o'clock in the morning. I was pacing back and forth. And I remember the bunk. I pulled out all my legal paperwork, my court transcript, my 115, and I started tearing up. I tear it up. I flushed down the toilet. And that one night, I remember just broke down and cried. And I said, please, God, if you really, really here, if you truly exist, I need your help. And I broke down, I cried. I never cried like that since I was a little kid. I held so much inside. And I look at myself in the mirror, I say, who is looking at me? This is not the person that I want to be. This is not the person that my parents want me to be. And that's the moment that I make a personal decision to change. And I start, where does change begin? I don't know change. What I knew at that time was criminality, violence, prison politics. And outside the yard, I remember all these individuals going to programs. I said, look at all these squares. Look at these guys. Look at these. Boom, and here I am. Ask for help. I want to change. I don't know where to go. Can you please show me? And I think that was a really pivotal moment. It's like breaking that arrogance and humble myself. And they were kind enough to go, let me go sign your classes. Come with me. If you need to talk, let's walk around the yard. Let's talk about it. And I remember in 2014 that we started the Lifers group out of the yard, unofficial Lifers yard. And it was first 5 people, insight. I don't know what's insight. I don't know what remorse, accountability, none whatsoever. That was a foreign language. Then we got a group, turned 5, it turned to 15. It came to 30, then it came to 50, almost 60 people right there in the middle of Folsom State Prison. I remember the watchman called the sergeant over and said, "Hey, what are you doing? You're not supposed to do this." So I explained to the sergeant, you know, we're doing rehabilitate program, we're doing life group. We want to heal, we want to do positive. And the sergeant said, okay, he left us alone. And, you know, just to build that community, right, and supporting and educating each other, sharing this information, come back more and all this helps a lot. Was I a perfect person? No. But I took, you know, really the grace of God and so many people to change my life and prepare not for the board per se, but understand who I was, where was my brokenness coming from, on the trauma that, you know, really bring me so much heaviness. And I understand that I need to heal. I need to really talk about this and just like really communicate that. And when I went to the board, thanks to Keith, Lily, and the whole Uncommon Law, bring out so many things that I thought I knew, but I didn't. So this is, you know what I'm saying, also the healing journey, but also the internal freedom, not the physical freedom yet, but the internal freedom of what helps, you know what I'm saying, bring me home.
Thank you. You've all talked about kind of the internal work that you've done. And Warren, earlier, when you were talking about, I think when you all are about to do the mock hearing, you shared about the program that you and Charlie work on with other folks on the team, Home After Harm. The work you are seeing and the community being developed on a pretty tough yard. One of those yards I was talking about that goes long stretches of time, months, maybe years, without any parole grants at Salinas Valley. You have guys who are engaging in this work and opening up, visiting some really difficult, like traumatic journeys for themselves. But you engaged in that journey before you came home. Michelle, you did too. See, you talked about yours. What was it like when you were going through it, trying to find spaces to do that work, trying to find support for that journey? Because this is a lonely journey. It can be, and painful.
I know for me, like programs existed, but I wasn't in the mind state or space mentally where I was trying to sit around a bunch of guys crying about past traumas. I used to look at them and soft ass dudes, man, sitting in this damn group. And I just had all these negative thoughts going through my head about what was going on in the group. But back then, the only way usually, because I wasn't such a good person, so the only way to get to Night Yard was to sign up for a group. And so I had to go sit in the group for 45 minutes to get to the rest of the half of the yard at night. So I just sit in there and I think, these soft. You know what I'm saying? Dudes in there crying, man, talking about their gangsters, you know? And I used to have all this negative conversation in my head, but then there would be moments of times where I could reflect and relate to what that person was talking about, the exact same incident that person was speaking on might have transpired in my life the exact same way. Then there was some shame in the fact that, man, he had the courage to speak about what was bothering him, and I was still letting it eat me up, acting like an ass on the yard. You know, these things that he was dropping off as he was going through life that were weighing him down, I was still picking them up and carrying them, trying to be a better person. That just wasn't happening. And so to go throughout that process and then to see it now with the people that we talk to in Home After Harm at Salinas Valley, oftentimes this is the first group they ever engaged in. And when they came in, you know, they sat, this race sat here, that race sat there, that race sat there. So at the onset, we're like, okay, nobody has to sign a check. You know, you come, you sit where you want. And over time, guys started to sit wherever they wanted to sit, and it broke up outside of the racial division. And for guys, once a couple guys started to share it allowed the space and the freedom for other guys to share their trauma. Because the group dynamic, when it's at work, is a beautiful thing to watch. Individual, as a substance use disorder counselor, I dealt with the group dynamic, but also individual counseling. And I always tell people the group dynamic, when it's at work, is such a beautiful and special thing, because other people can benefit from one person sharing, where I might not have the courage to talk about something in the moment. When I hear somebody else talk about it, there's such a relatability that goes within the room, that goes around the circle. And that's the kind of space that me and Charlie have kind of created at Salinas Valley, where the guys who witness violence all the time, and at Salinas Valley, there's rarely ever a yard. Like yesterday when the guys came to group, they hadn't been outside in a couple of days. And so when they come to group, instead of being ornery and pissed off about what they're not getting, there's such a joy and an honor to come to group to be able to talk about what's bothering them and create the space to where they're learning about how to respond versus react, how to talk about character defects and why things keep popping up and why I can't let certain behaviors that the staff exhibit against me. Why do I need to take every battle as a war? You know, and watching them blossom in their understanding is such a powerful thing. And, you know, they want more nights of group. You know, it was, I mean, we can go to this group 2-3 nights a week, you know. And I know for me, myself, I understand that self-esteem comes from doing esteemable acts. And doing the next right thing gets a little easier, just like doing the next wrong thing got a little easier. When I thought nobody cared about me, it was easy for me not to care about anybody else. But as I started to see people come and help, and some of the people in our group, I walked the 4-yard. You know, so I know when the first night I came back in, they were just blown away. Like, not only are you back, how the hell did you ever get out? You know? And so there's that. And so there's this buy-in. When I go to Lancaster, it's the same thing. I know people there from when I did time there. In both the yards that Home After Harm is at, I did time on them yards. And so to be able to go back and deliver the message of hope, but not just the message of hope, the message of the power of transformation, I think is a really potent tool in them places where very little hope resides.
What I can say about my process was, like, in prison, you know who's in the zone, you know who's doing right, you can just see it. This person they've gotten their stuff together, they're making those next right steps. And when it came time for me to prepare for my first board, I reached out to women that were going to board or had gone to board and said, will you sit with me? Can we, you know, pop a squat in the day room? I'll bring the coffee and the chips, and, you know, can we run through questions? Can you look at my relapse prevention plans? I remember Barbara, I asked her, I said, do you have some formats that I can use? Like, anybody that I knew that had their stuff on point, I was like, can I get a page from your book? And so that's really the best thing to do, is to network with people you know have something that you want to get. And what I found is most people want to be helpful. And it's kind of like, as you're moving forward, you reach your hand back and you pull that next person, right? And that was part of the process that I started taking advantage of, and it made a big difference.
Just to add one more thing, the other night in group, you know, we're dealing with causal factors and insight in the curriculum. And there was always a conversation about what insight is, because as we talk about it, it's not really defined what it is. And in 2020, we had a group called Operation Transformation in the chapel, where a few lifers, that's about 12, 15 guys used to meet. And we were at the board talking about what is the working definition of insight. And that man right there, and I was telling him, I hadn't seen him since I've been home, that I used his definition like 2 weeks ago in group when we were just talking and throwing things out there about what insight looked like to us. And that man said his definition was explaining what happened before what happened. And we all just kind of sat back and thought about it. Like, you know what? That actually makes sense, and that became our working definition in operational transformation of what insight was. And I actually shared that with the group at Simmons Valley like 2 weeks ago. I quoted that, and the guy was like, "What happened before? What happened?" Yeah, man, I can get with that, you know, and it's just to make things relatable and powerful, and just whatever it takes to spark that light is a beautiful thing.
Thank you. And so I met Warren for the first time about four years ago, right? When he was figuring this stuff out. Now his full-time job with us is helping people figure this stuff out. More importantly, creating a community in which people can be supported in figuring this stuff out. This is what's possible. I have other questions, but I want to find out if you have questions for these folks about the process, anything you haven't heard them talk about. We got some time. Any questions you all have for the panel? Go ahead.
My question is, what is, like, what's one piece of information that you think we, as the people helping those still living in the facility, that we should like share with them or highlight for them or water for them?
So what is something that folks here on the outside who have loved ones inside, supporting people inside, what is something we could do to share with them, to provide to them that maybe haven't talked about?
Maybe learned after the fact that it's not commonly talked about inside the facility, like things of that nature.
Something you maybe learned after you came home or after you were going through this process that the folks could have provided for you. Anything?
Something really simple. While you're inside, you have all the time in the world to get something like your birth certificate. And coming out, if you have to get ID, and then after you get your ID, then you can get your social security card. And then once you get your social security card, then you can work, right? So everybody wants to jumpstart making that money, especially the longer you've been out, the more we feel behind. So one of the pieces of advice I keep sending back in, get your birth certificate now. Start getting your documents now, because when they come out, it takes so much longer, and we really don't have the time. So that's like my number one thing I always say.
One of the things that I would say as a family member supporting a loved one who's incarcerated, help them learn how to be accountable and hold them accountable. About 2020, I had this love affair with cell phones. Prior to my last 6 115s were for cell phones. And I didn't care what the consequence was, I had to have them. Because who am I without one? It's how I was dealing with it internally. It was, definitely something that I had to have for a long period of my incarceration. And my family members used to always be okay with me calling. There came a time to where my family said, don't ever call me. And they called my other friends and said, if you love Warren, you care for him, you want him to come home, don't ever accept a call from him if he calls from a cell phone. And that accountability right there, and even at the beginning, I would go to the phone to call them at the payphone, then I go back on into the cell to get on the cell phone to, watch movies or do whatever. But that helped, that accountability helped me along the process to where I knew the people that loved me were going to hold me accountable. And it was more important for me to go home than to talk to them in the middle of the night. And so the accountability aspect of what you could do for your loved one, and talk to them. Tell me about insight. Tell me about your crime. Tell me about your relapse prevention plan. Have a partnership with your family member or loved one, because nobody does it by themselves. I always say it's an inside job with outside help. Internally, I can't want my loved one to come home more than they want to come home themselves. And so, you can be there for them, support them, and you can send them all the packages in the world and all them other things, accept the calls. But if we're not helping them progress forward and ultimately being found suitable, you know, can we really say that we love them if we don't want to do whatever it takes for them to come home? Sometimes these are some hard conversations to have. But oftentimes for the ultimate goal, if it's for them to come home, they're ones that need to be had.
I mean, accountability is really important, but also to balance it out with being supportive, because a lot of individual inside already carry something heavy, a lot of trauma, a lot of guilt, shame already. And when a family member like proactively want to talk about the past, I know that, you know, I asked my mom from the beginning, they didn't want to talk about it, especially like my dad were killed in a car accident, you know? I need some answers to heal from that too. What happened in the Vietnam War? What happened to Dad? What happened to you? Dad was injured. He was throwing an education camp and everything like this. My mom wouldn't answer at that time. Maybe she may be afraid that I may feel a certain way. But I said, Mom, I need these answers. Can you please let me know so I can put my life puzzle together? Because right now it doesn't make sense to me. I feel like there's something missing. I just can't figure out. I know that, you know what I'm saying? Please help me. Then my mom started opening up a little bit, and a little bit more. And I'll talk to my brother, my older brother and sisters, open a little bit more. And I come to realize that it helps me as much as it helps them. Because they've been holding this so much deep inside that they carry this burden and this pain that we'd be able to talk about. And we were able to heal from it as well. So I think not just being understanding, be empathetic, and have that real honest conversation and be able to listen and be supportive.
That's great. I mean, you really are key to helping them sort of figure out all the pieces of the puzzle. And the thing I add about that is, in response to your question, like, what can you do? What can you give them? You can give them permission to tell the truth. We keep so many family secrets, so many lies, so many things we just refuse to acknowledge in person. Sometimes it's about the crime. Sometimes it's about a lot of other stuff in your family. Stuff that you just don't dare talk about. You will sit in the visiting room all day and talk around it. Talk about the weather for 4 hours. But not ever get to the deep stuff that you both want to connect about. And folks inside are sitting with the shame and the pain of what they caused, what they did, and also stuff they experienced. Some of you hold the key to unlock the door around that's blocking their access to really revisit that trauma. And they figure, well, if I go to the parole board, they're going to ask me about my childhood and stuff. And I'm not trying to say nothing bad about my mama. A lot of people spend years, decades in prison, not wanting to disclose what actually happened inside the house. Barbara, you had to add.
How important was hope and faith, and did that play a part in your transformation? Did you believe in getting that thing?
How important were hope and faith? Did it play some part in your efforts to come home?
Everything. Hope and faith. Faith in a power that's greater than me. Faith. You know, every morning there are dark days, dark moments, sit in that cell, feel this lonely nights, feeling this whole burden of the world as it's gonna fall down. Right? There's like, am I ever go home? I start questioning, having this fear. But you know what? Hope is the light that keep me moving every second, pushing forward. I think without hope, right? I think it's gonna take me longer to come home because I can easily give up. I just say, you know what? I'm done with this. I'm done going 1,000 program. I'm done going to school. I'm done with this. I'm cool. Then I have to remind myself, my family did not give up on me. Why do I give up on them? Give up myself? No way. But just come to that faith and that hope is the core of who I am today as well. Right? So it's really important. It's vital. Not just, saying going through the board, but it's going through life journey as well. So
I'd like to talk about hope as well, going from LWAP to what I now have the possibility of walking out was everything. Everything. These two gentlemen beside me knew that there could be a pathway. It did exist. I had zero. So when that opened up, not only did I say, oh my, I have the ability to walk free one day, I also looked inward and said, okay, so what else do I need to work on? And there's a way that you can help your loved ones inside by asking them a question like, what do you have in your locker right now that you can get a 115 for? Because when you really want to be free, you're going to do that next right thing. I challenge myself. Well, actually, my lifer friend said, Michelle. So now that you're going to board. So if officer so-and-so, and there's always that one officer that they all talk about that is hell on wheels. If this officer were to come into your room right now and go through your locker, what could they write you up for that you could lose your date? Because now guess what? You have a date to lose. I took everything out of my locker, and it was really hard because I had 30 years worth of really good contraband. And I got rid of it, right? I'm not gonna lie, right? I had some good stuff. Back in the day, right? But I had to ask myself, do I want this pair of scissors, right? Or do I want to know that anytime I hear the goon squad running down the hallway to come to my door, keys jangling, they can walk in, I can say, yeah, no, go ahead, right? Along with my sobriety. So to really be supportive of your loved ones inside, be also willing to challenge them and say, how are you living right now inside that anything can happen? Any officer can come up to you, room search, whatever, and you'll be able to say, not a problem. Because that's really the person that you want to see step out of prison to begin with, right? So start encouraging that behavior now.
For myself, there was always a little bit of faith. There was often very little hope, and it kind of seems backwards. But that's kind of where I was, because for the first 15, 18, 20 years, it was Pete Wilson, Gray Davis, Arnold Schwarzenegger. Life meant life. Whether you had life without life, you were going to die in prison, and it was firm on it. And I think Schwarzenegger kind of cracked the door open a little bit, then it opened a little more with Jerry Brown. And then some hope started to come in. And then especially in 2016 with SB 260 came into play. And the youth offender law, then SB, and that kind of didn't hit me. Then SB 261 came on the heels of it. And I was like, okay, this can happen, and like I said, the hope was accelerated by seeing people who had a similar background of rule violations like I did. I had 28 of them start to walk out the door. And I remember my window at Tracy faced the parking lot. So I used to watch guys get off the van, hug their loved ones, jump in the car, and I used to be in the window crying, and just joy, but just immense sadness that it wasn't me. And watch them drive and work a school call, and I put water on my face, act like I'm cool, and walk out the door and sit with the fact that, man, I just watched my boy leave after 30 years and kind of had the same path I was on. Just he figured some things out before I did. And I remember buddy of mine, Jason, what's up? He used to be so hard on me, because he was a really hard dude early on in his incarceration. And to see him transform his life to where he wasn't gonna do anything wrong, it was just foreign to a lot of us. And so you could be sitting there and doing anything that wasn't productive towards going home. You could be at the card table, just work 10 hours, you're tired, we go play hand of pinochle. And he'd come up behind your back and I see you still working on that card game, huh? Yeah, it's gonna be real helpful at the board. And just walk off and just be so mad. Be so mad. I'm just trying to blow some steam off, man. I can't do this all the time. But there was so much truth and power and potency in what he said, because it took me a few conversations with him, and he was my cellie for a while, to move upstairs to L3 to the honor dome. Because I didn't want to move up there, man. Them sucker dudes up there, man. I don't want to live around them dudes. But all them dudes were going home. And so there was obviously something I was missing that I knew internally that I wanted to be a part of. And that just kind of propelled where I went. And I wish it would have happened sooner. I wish I didn't have to wait 32 years to figure some things out. You know, I see people that now, I got nobody that just recently got paroled. He had 15 to life, 11 years. You know, crime happened at 20, he's out at 31, got a whole life ahead of him. 31 years old after doing a life sentence. You know, I came out of prison at 52, you know, and so it's just to see where it once was, where there was zero hope, to where all the hope that's involved now, and faith plays a huge part of that. As a believing man, I understand that none of this is of my own doing. I'm incredibly grateful, especially to have the job that I have with Uncommon Law, because like she said, Uncommon Law, when I was incarcerated, was like the gold standard of information, you know. And when you came in 2019, and I remember the conversation we had after I presented my timeline, and I went over to you because I didn't know you were going to be there that night, and it wasn't set up or anything, that I was scheduled to present my life crime. And when you and Julie were there and I presented my life crime, I remember coming up to you afterwards asking, and you said, if you do it just like this, you'll get out of prison. And I remember saying that I was getting ready to go to the board in a couple months, but I had been in trouble. You said, you might not get out this next time, but you keep doing this, you'll get out. And sure enough, it was true. Then DVI sat down. I was able to go put my substance use disorder counseling certification in my pocket, and I got found suitable, and I got out, and the rest is somewhat beginning a new history.
So I don't know how we go on after that. We could take more, but I feel like we worn these folks out. You all look a little tired too. Before we go, I have to make sure we know the food that we had for lunch is from Falafel Corner, which is owned by a formerly incarcerated guy who does catering. They have a shop here in the East Bay. Check them out, support them. I think we have some more left for people who want to take some home. That maybe what those bags are on the table there. If we have any more pressing questions that you have right now, we'll take it. Otherwise, I will say thank you to the panel. Thank you to all of you for being here for Life from School here at Midwest. Thank you. We'll see you all next time. Again, if you take a minute, scan the QR code, you can do the survey. We'll also send it to you on email, along with a link that actually has the slide deck and other materials that we saw today. Thanks, everybody.
Likewise.